Very good morning, everyone, and welcome back to this second day of our conference.
Please bear with us for a minute or two. We'll start shortly. Thank you. Thank you. Honorable the Chief Justice of Gujarat High Court, Srimati Sunita Agrawal, honorable dignitaries across the aisle, honorable members of the District Judiciary and fellow lawyers, a good morning and a warm welcome to day 2 of the conference. Yesterday, we reflected on the foundations of arbitration, autonomy, efficiency, and judicial restraint. Today, we build on that momentum with sessions that take us deeper into the practical workings of arbitration, from interim reliefs to enforcement of awards. With such an exceptional lineup of judges and senior advocates once again before us, we can look forward to another day of rich and engaging dialogue. With that, we request Mr. J.G. Shah, Registrar, SCMS and ICT, High Court of Gujarat, and Mr. V.R. Solanki, Assistant Director, Gujarat State Judicial Academy, to escort esteemed chair and panelists to the stage. We have amongst us the esteemed Chair, Honorable Justice C. Hari Shankar, Judge, Delhi High Court.
The senior, so I think it applies to me as well.
Justice Sangeeta K. Vishan, High Court of Gujarat Judge, Dr. S. Muralidhar, Senior Advocate Saurabh Soparkar, Senior Advocate and King's Counsel Nakul Diwan, and Advocate Anirudh Krishnan.
Before we commence the session, we have the honor of introducing the esteemed chair and the panelist. We have amongst us as the chair for today's panel, Justice C. Hari Shankar, Judge, High Court of Delhi. Justice Hari Shankar completed his LLB from Campus Law Center, Delhi University. After 2 decades of distinguished practice across courts and tribunals nationwide, specializing in indirect taxes, regulatory law, and government litigation, he was designated as senior advocate in 2014 and was elevated to the bench in the year 2017. Justice Hari Shankar has since authored several landmark arbitration judgments that are frequently cited. Honorable Justice Hari Shankar ruled that Indian courts have the authority under Section 9 of the Arbitration Act to grant anti-enforcement injunctions and restrain a party from enforcing foreign decrees when such actions threaten the arbitral process in India, one of which is the earliest of such judgments in India. Justice Hari Shankar has upheld the principle that once a tribunal is constituted, courts must ordinarily defer to its primacy in granting interim measures. These contributions have strengthened the arbitral autonomy, clarified the court's supporting role, and deepened India's alignment with the global arbitration standards. With such breadth of expertise, Justice Hari Shankar is uniquely placed to guide us in today's discussion for the first session. Thank you, Your Lordships, for chairing the session.
Our first panelist is Honorable Justice Sangeeta K. Vishan, Judge, High Court of Gujarat, who brings nearly 3 decades of distinguished experience at both the bar and on the bench. Since enrolling as an advocate in 1994, Justice Vishan represented the state of Gujarat across a range of complex constitutional, civil, service, and industrial matters, serving in key roles such as assistant government pleader and additional public prosecutor. Appointed to the bench in 2019, Justice Vishan has delivered clear, pragmatic judgments that contribute meaningfully to arbitration jurisprudence. Her rulings have clarified the issue of grant of interim reliefs, aligned anti-suit injunctions with established international principles, affirmed statutory arbitrations in government contracts, and addressed termination or substitution of mandates and arbitrators under the Arbitration Act. Justice Vishan's comprehensive experience as both advocate and judge provides invaluable insight for today's discussion. Thank you, Your Ladyship, for being the panelist today.
Next on our panel is Dr. S. Muralidhar, whose distinguished career exemplifies the integration of scholarship, advocacy, and judicial leadership. As a first-rank law graduate and holder of a doctorate in criminal justice, Dr. Muralidhar has served with distinction on the benches of both the Delhi and Punjab and Haryana High Courts, and notably as Chief Justice of the Honorable Odisha High Court. His reputation is founded not merely on his titles, but on an enduring commitment to fairness, innovation, and expanding access to justice. His leadership in initiatives like paperless courts and expanded legal aid highlights his progressive vision for the legal system. Dr. Muralidhar has made significant contributions to arbitration jurisprudence. He has consistently underscored the importance of judicial deference to arbitral awards, advocating for court intervention only in instances of manifest illegality or breach of fundamental principles. Thank you, sir, for being with us. We welcome you on the panel.
Our next panelist is Senior Advocate Saurabh Ensoparkar, whose country is one of the leading respected counsels in tax, corporate, and arbitration practice. Sir, an academic standout throughout, holds distinction degrees in commerce and law. An All India rank holder in chartered accountancy, he has combined intellectual brilliance with 3 decades of courtroom experience. Early in his career, he appeared as Senior Income Tax Counsel for the department, opposing the legendary late Sri Nani Palkiwala, before building a practice that now spans corporate, commercial, and arbitral disputes. Sir has been a visiting professor at IIM Ahmedabad for over 2 decades, teaching corporate tax and business law, and continues to mentor the next generation of lawyers and professionals. He has also held leadership positions in association and educational institutions, reflecting his deep commitment to legal community. In the field of arbitration, he is widely sought after for his sharp advocacy in complex commercial disputes and clarity on procedural fairness. A warm welcome, sir, and thank you.
It is our privilege to introduce Mr. Nakul Diwan, a distinguished practitioner in international arbitration, an alumnus of Sri Ram College of Commerce and Delhi University's Faculty of Law. He went on to pursue his LLM jointly at New York University and the National University of Singapore, where Sir now also teaches arbitration and dispute resolution. Mr. Diwan's professional journey spans 3 jurisdictions, that is India, Singapore, and England and Wales. And he has recently been appointed as King's Counsel, a rare honor. He appears regularly as both counsel and arbitrator in high-value disputes before leading arbitral institutions such as SIAC, ICC, and LCI, and has played a pivotal role in cases shaping Indian arbitration law in areas such as foreign seated awards and the group of companies doctrine. He is also the chief editor of Enforcing Arbitral Awards in India, a leading reference on arbitration practitioners. Peers and international ranking recognizes him for incisive advocacy, innovative argumentation, and his ability to bridge Indian practice with global arbitral standards. His presence on this panel adds both depth and a value to international perspective to our deliberations. Thank you, sir, for your participation.
Our last and the youngest panelist is Sri Anirudh Krishnan, who represents a rare combination of academic excellence, practical depth, and policy influence in arbitration. A graduate of Nalsar University, he passed out in 2008 with top honors. He then went to Oxford for his postgraduate studies and is now a fellow of the Singapore Institute of Arbitrators. He has handled high-value arbitrations under ICC, LCIA, SIAC, ICSID rules, and has also appeared before Supreme Court of India and the Singapore International Commercial Court. His policy footprint is equally significant. He has advised the Law Commission of India on arbitration reforms and serves as the chief editor of Justice R.S. Bachawat's Law of Arbitration and Conciliation, the most cited authority in the field. Mr. Krishnan's advocacy has also shaped important precedents, from clarifying limitation issues to strengthening Section 34 scrutiny and ensuring fairness in arbitral appointments. His voice blends academic, practical, and institutional aspects, making him an indispensable contributor to today's panel. Thank you and a warm welcome.
May we now request Honorable the Chairperson, Justice Harishankar, to take the proceedings forward, please. Thank you, sir.
So first, thanks a lot for calling me here and giving me the honor of chairing this session. Let me first of all say that with Justice Muralidhar as part of this, I'm not a chair, I'm just a moderator. I can't possibly be a chair with Justice Muralidhar here, and I told him that at the very beginning. He is not just my guru, probably all of our... Anyway, characteristic ability. Anyway, so we have four topics essentially for today's session, and the general, it's kind of, we're just going along with it as the proceedings go on. So the first topic that's been put up for today is regarding interim measures under Section 9 and 17 of the Arbitration Act. And my learned sister, Justice Sangeeta Vishen, would probably be speaking partly on it, and Justice Muralidhar would speak, but a little later after this, so that it doesn't overcrowd the proceedings. So on 17, there are several issues which arise. I'll just highlight a few of them for this, so that the speakers can take it further. One is, we all know that 9 has been amended. There was an amendment in 2016, then there was an amendment in 2019. 2019, they brought in 9.3, and with 9.3 now, if one reads 9.3 as it stands, then there is a requirement of a positive existence of a finding that it is not possible to obtain interim measures from the existing arbitral tribunal for a court to obtain a Section 9 if an arbitral tribunal is already in existence. So that is to the extent to which that is applicable, and this of course follows. It will also involve the ArcelorMittal judgment of Justice Indira Banerjee, where her ladyship had also said that once an arbitral tribunal is in existence, the question of the court passing interim orders under Section 9, it's not a bar, but court always take a view not to do it. Now, when I was sitting in the 9 jurisdiction, this issue used to come up before us again and again. And it was always a question as to whether I should exercise jurisdiction once, since there's an arbitral tribunal already in existence. And I mean, honestly speaking, perhaps if you go through my judgments on the point, there may be some inconsistencies also, because we had to go on a gut feeling on a case-by-case basis as to whether to grant it or not grant it. Several issues arise there as to whether the party actually has is intent on starting arbitration. Has he issued a 21 notice? or is it just 9 being treated as a pre-arbitral 39(1)(2)? Because one of my views was that a 9 cannot be treated as a pre-arbitral 39(1)(2). But these are all issues which would arise when it comes to a 9(3), its application. Then, of course, you have 9(2), which was inserted in 2016, which says that the arbitral tribunal has to pass its render its award within a particular period. Now, the question that arises, I mean, if the if an interim measure is passed, then the arbitration must be invoked within a particular period. Now, the question is, what happens if that period is exceeded? That is again a question which I think my sister Justice Vishen would be addressing. One way of looking at it is that it's basically a conditional interim award, interim order, and if you don't, it is conditional on your invoking arbitration within a particular period. If you don't invoke it, then the interim order goes. That's one way of looking at it. But of course, that's again something which is subject matter of a lot of debate. Then we have Section 9 being invoked, then that's all pre-arbitration. Now, during arbitration, the whole paradigm changes. Because there is an arbitral tribunal in place, and the first thing that comes to mind is, why should the party not go to the arbitral tribunal? What's such an emergency that the court should interfere, even if Section 9 was invoked before the arbitration commenced? That again becomes a thorny issue when it comes before courts, and I'm sure many of the commercial courts would be dealing with such problems. Then post-arbitration, though there are not many post-arbitration Section 9s, we had one in our court very recently which created a lot of confusion, and in fact that has traveled to the Supreme Court also. And sometimes what happens is the question, a Section 9 is invoked post-arbitration either by the award holder or by the award debtor. And in each case, questions arise. If it's the person who is the award holder, why doesn't he move for enforcement? If it's an award debtor, it becomes even worse. Why doesn't he ask for an interim order under 34? So that again is an issue which arises. So is it a case where the provisions have, the property has to be secured, which brings in the issue of the extent to which the CPC would apply in such cases? Will Order 38 Rule 5 apply? Will the Ramanayan Foundry decision of the Supreme Court apply? Do you have to prove dissipation of assets? So many issues arise when one deals with 9 and 17, and frankly, it is something which can be a subject matter of unending discussion, since even in the Supreme Court judgments, there is some amount of some parts are still a little hazy. So these are all issues which arise. And then a last issue which may probably be of significance in this context would be enforceability. Enforceability of orders which are passed under Section 17, though now there is a provision under 17(2) which says it can be enforced like a decree of a court. But to the extent to which that is working, does it actually operate that way? To what extent can you invoke 39(2)(a)? Can you go in for contempt in such cases? These are all aspects which would arise. So these are all issues which arise in the context of 9 and 17, and which I'm sure would engage the attention of commercial courts in this state as well. So with that small introduction, I'll now hand over the floor to Justice Sangeeta Vishen, who would take it forward. I think she would be addressing some of these issues, and Justice Muralidhar would be addressing certain others. So Justice Vishen, please carry it forward. Thank you.
Thank you, Justice. Thank you, Justice Hari Shankar. At the outset, I may extend my gratitude to Honorable the Chief Justice for giving me this opportunity. And I also deem it a privilege to be part of this panel chaired by my brother Justice Hari Shankar, Dr. S. Muralidhar, Saurabh Bhai, Mr. Devan, and Mr. Anirudh Krishnan. As my brother has stated, I'm going to speak on Section 9 and Section 17. I've just divided into 4 segments. One is legislative background, pre-amendment and post-amendment, interplay of Section 9 and Section 17, and the applicability of the provisions of the Civil Procedure Code to Section 9. Whenever we talk about the arbitration law, what occurs to us first is the UNCITRAL model law. The United Nations Commissions on International Trade Law has adopted the model law. So also the conciliation rules of 1980. The idea behind is to maintain the uniformity of law or the arbitral procedure and specific needs of arbitration practice. I have just prepared a short PPT for the easy understanding of the provisions of the article and Section 9, Article 9, Section 9, Article 17, Section 17. Article 9 of the Ancestral Model Law gives the power to the court to grant interim measure. Section 9 is a replica of Article 9, which gives the powers to the court to order interim measures. If we see, there are many segments, rather many parameters, namely appointment of the guardian, appointment of the receiver, protection, preservation, so on and so forth. Article 17 of the Ancestral Model Law also provides for the powers of the tribunal to grant interim measures. Section 17, which was initially prior to the amendment, only provided that unless otherwise agreed by the parties, the arbitral tribunal may, at the request of the parties, can grant interim measures. The issue arose and it traveled up to the apex court in the case of Sundaram Finance, which is reported in 1999 to SCC, page 479. The issue was regarding the interpretation of the term before. What does it mean? Whether after Section 21 or prior thereto. The apex court has interpreted it to mean, I'll just read the relevant portion, that before or during the arbitral proceedings, and it contemplates two stages when the court can pass interim orders. Though Section 17 gives the arbitral tribunal the power to pass orders, the same cannot be enforced as an order of the court. It is for this reason that Section 9 gives the power to the court to grant interim measures. Yet in another decision, in the case of MD Army Welfare Organization, reported in 2004-9 SCC 619, the apex court held that the powers under Section 17 are very limited and it does not confer upon the tribunal to enforce its own order or by the judicial enforcement. This led to the amendment in the year 2015. Even the Law Commission was of the opinion that efficacy of Section 17 is highly compromised. Section 9 was amended by incorporating subsection 2. On the other hand, Section 17 was also substantially amended. Section 17 was then brought it at par with Section 9. So all the powers which were available with the court under Section 9 were now available with the tribunal under Section 17. It is said that prior to the amendment, the provisions under Section 17 were toothless. But after the amendment, the provisions of Section 17 were given the claws and the teeth. This takes me to the another topic of interplay of Section 9 vis-a-vis Section 17 of the Act. As my brother Justice Hariharan has stated, that it involves three stages: before, during, and after. After the passing of the award, but before its enforcement. So far as the stage before is concerned, there cannot be any debate on that. The issue is only when the arbitration proceedings are pending before the arbitral tribunal. Now, whether the court should entertain the application under Section 9, but after the amendment, it has been observed that Section 9 was amended by incorporating subsection 2 and Section 3 with a view to reducing the role of the court. Now there is one window open in Section 17 regarding whether the remedy is efficacious or inefficacious. If we see subsection 3 of section 19, section 9, I'll just read it out for the benefit of everyone. Once the arbitral tribunal has been constituted, the court shall not entertain an application under subsection 1 unless the court finds that circumstances exist which may not render the remedy provided under the section 17 efficacious. So here the element of whether the remedy under section 17 is efficacious or not, that kicks in. This issue again has been considered by the apex court in one of the judgments, wherein illustrations have been provided that what are those circumstances. In that very judgment, the apex court has said that what if the arbitral tribunal is at a far off a place, and it is impossible to constitute the tribunal and grant the interim relief. At that time, an application can be filed under section 9 before the court. Even in one of the judgments of the High Court, it has been stated that lethargy of the arbitrator. Then also an application can be filed under section. But the fact remains that the scope of section 9 has been limited. The role of the court has been limited. The next question which then would arise would be whether the provisions of CPC applies to section 9. Here also, the apex court has interpreted as to whether the provisions of the code strictly applies or it is only the guiding principle which the court should keep in mind. In the case of Adunik Steels Limited, 2007-7 SCC, the apex court has held and observed that when a party is given a right to approach an ordinary court of country without providing a special procedure or a special set of rules, in that behalf the ordinary rules followed by that court would govern the exercise of the powers conferred by the Act. It is not possible to keep out the concept of balance of convenience, irreparable loss, and prima facie case, so also the concept of just and convenient, while passing the interim measures. There are two other judgments of the year 2018 and 2022 itself. In one of the matters, the apex court found that the principles of Order 38 Rule 5 were not followed. The apex court observed that it ought to have been followed, not provisions of 38 Rule 5, but the principles enumerated therein should have been followed. Similarly, in the case of Sanghi Industries versus Ravin Cables Private Limited, reported in 2022 SCC Online 1329, the order was quashed by the apex court as the court found that the requirement under Order 38 rule were not satisfied. Recently also, that in 2022 itself, in the judgment of SR House Private Limited versus ArcelorMittal Nippon Steel Limited, reported in 2022, 20 SCC 178, the argument put forth was that the provisions of CPC should be strictly applied. The apex court, while deciding the said issue, has observed in para 38 that while deciding a petition under section 9, the court cannot ignore the basic principles of prima facie case, balance of convenience, and irreparable loss. It has observed that the power of the court to grant relief is not curtailed by the rigors of every procedural provision in the CPC. The court is not strictly bound by the provisions of the CPC. In fact, it is very interesting observation made by the apex court that the technicalities of the CPC cannot prevent the court from securing the ends of justice. The relevant observation in para 48 reads thus: if three celebrated parameters are satisfied in favor of the interim relief being granted, the court, while exercising the powers under Section 9, should not withhold the relief on the mere technicality that mere technicality of absence of averments incorporating the grounds under Order 38 Rule 5. I would just like to say that since inception from the year 1996, from the date the act was enacted till the recent 2019 amendment, changes have been brought to minimize the role of the court. As has been yesterday also referred by all the speakers, that the objective of the Arbitration Act is to be fair, honest, and speedy. While concluding, I would also like to just take note of one another provision, which is not incorporated, but it finds place in the recent Arbitration and Conciliation Amendment Bills 2024. The Law Commission report has observed that judicial intervention in arbitration proceedings adds significantly to the delays in the arbitration process and ultimately negates the benefits of arbitration. Amendment is suggested in the definition of the arbitration by incorporating 2EA, expanding the definition of arbitrator by adding the emergency arbitrator. Corresponding provision is Section 9 capital A. And if we see, it gives the powers to the council to appoint the emergency arbitrator. That will be during the arbitration proceedings for the interim measures. If this amendment is introduced and takes the color of the enactment, then the role of the court would be rather totally, it may happen that, in that very section, Section 9 also, the term during arbitral proceedings is proposed to be deleted. If that be so, then powers of the court under Section 9 during the arbitral proceedings would be taken away. Recently in the judgment in the Amazon.com in 2022, 1 SCC, two important questions arose. It was an order challenged on order passed under Section 17(1), and enforcement was sought for. The apex court observed that subsection order passed under subsection 1 of Section 17 is for all practical purpose enforceable under the Act itself, under Section 17(1) itself. So after the amendment, it might happen that the role of Section 9, the role of the court under Section 9 perhaps would be taken away. Thank you very much.
Is there any other speaker who would like to supplement what Justice Vishen has said or add anything to it?
No, not it.
So, Justice Vishen, there are just 2 points which I had just noted, on which, if possible, could you just on the points which you had just mentioned.
Yes.
The first was, there is this 38(5).
38, yes.
The applicability of 38(5) to
Yes.
cases which fall under 9(1)(2)(b). It will come under 2B because 38(5) would apply only where there is a question of securing the amount. Now, in Ramanayan Foundry, because this is something which used to come before me when I was in the High Court, and I still am grappling with it. Though I have passed decisions on the point, I don't know how good they are. But because Ramanayan Foundry was in that, the Supreme Court said that in 38(5), not only have you to show that the person against whom the other side is indigent or in financial weakened circumstances, but you also have to show that he is dissipating his assets in such a way as to defeat a possible award. Now, when I was sitting on the arbitration roster, this was an issue which used to come very often because the defendant will say, the plaintiff or the petitioner, 38(5) petitioner would say, 9(1) petitioner would say, look, he is in a he is in a very bad condition, and they'll show his balance sheet that he's been in loss continuous. So even if I get an award, I may not get it. But the other side comes up and says, I may be in a bad condition, but I'm not dissipating my assets. So that brings in whether the 38(5) strict principles under Ramanand would apply, or can the court modulate it on a case-to-case basis depending on the facts which are before
No,
us?
as I referred that Sanghi Industries judgment, wherein the apex court, Sanghi Industries and SBI versus Sony Ericsson, that the court said that the mandate of Order 38 Rule 5 has to be strictly followed. So one needs to see the parameters as indicated in Order 38 Rule 5. If it falls, it did not be the provisions of 38(5) are to be strictly followed, but at least the principle, enunciated principle, guiding principles are to be followed. Then again, it will be on the facts of each cases, whether the motive of the party, whether he is trying to avoid or he is not trying to avoid. So it will depending upon the facts of the each case.
Is there anyone?
Could I say?
Yes.
See, provision of Order 38 Rule 5 has always been accepted as drastic provision. Because even before a decree is passed, you are attaching the property. So unless a very clear case is made out, not only of possibility of success at the end of the road, but also there is a possibility of the defendant or the opponent likely to dissipate the asset, probably on a mere allegation. Order 38 Rule 5 may not be justifiable at the court level, so also at the arbitrator level. Because it's something very drastic. You are prohibiting a person from enjoying his own property pending a possible decree against him or possible award against him.
If I may also just come in on one
Yes.
aspect. There is a potential conflict between the judgments in SR, Justice Indira Banerjee's judgment, and Sanghi, because SR provides a little more play around the joints. Whereas when you look at Sanghi, they say Order 38 Rule 5 will be strictly incorporated. But I think, subject to correction, there is a Delhi High Court judgment that takes the view that SR will be the underlying principle. That will have to be followed.
Anirudh, this judgment of 2018, SBI versus Sony Ericsson, there the court has categorically observed that if the mandate of Order 38 Rule 5 is not followed, then the order is to go. As against this, in the SR judgment, there again the apex court has said that the guiding principles of Order 38 Rule 5 are to be followed. So there appears to be some divergent of views, even in Sanghi Industries also, that if the requirements of 38(5) are not satisfied, then what? But then again, we'll have to.
Because I think one of the issues that would guide it is that unlike a case where 38(5) is being exercised by a civil court, the idea of Section 9 is to protect the arbitral corpus. It is not protecting property per se, but you are protecting the arbitral corpus. You are trying to see that the arbitration is not rendered futile. So if there is any particular situation in which you feel that the circumstances being shown are such that if this arbitration is allowed to proceed, and even if it culminates in an award which is favorable to the petitioner, to the Section 9 petitioner, he may get nothing, either because the party is downhill and rock bottom, or because the party is dissipating his assets. I think a court can, in a given case, legitimately exercise 39. I think it may possibly be on a case-to-case basis. There's just one other.
On the facts of the case,
Yeah.
whether the.
One other point, Justice. Yes. Yes, Nakul. That's why I use this. That's a
We made it a provision.
that's a little iffy.
Going to pick up something on a 38(5), but on what Justice Vishen said about emergency arbitrators. So if there is, I mean, if you're going to be asking a question on that, then there's something that I'm very happy to share with you.
Please go ahead. We don't have to ask questions.
Very well. So I think Justice Vishen touched upon a very relevant concept of emergency arbitrators and how the legislation may be amended to include that within the concept of, emergency arbitrators being constituted to grant interim relief. Now, it's very interesting because the concept originated about 10 years ago in Singapore, where the SIAC brought in that concept. And when we were debating whether such a concept would work, there were a lot of skeptics. The reason why there were skeptics is because parties had never chosen a system where the institution could, within 48 hours, appoint someone of the institution's choice to grant an emergency measure. Now, when we did the Amazon versus Future Retail case, which I think a lot of you may have heard of, which was actually an SIAC arbitration seat in New Delhi, and we were looking at getting an injunction against the Future Group, which was a very significant injunction. I think that the stakes in that were close to $1 billion. The issue that arose before the court was whether, in an India-seated arbitration without a legislative provision, an emergency arbitrator could injunct a party and whether that would become an enforceable order. And when we were debating where to go, this was certainly a consideration that we had. Should we go to the Delhi High Court in a Section 9? Or should we take our chances and go to the SIAC asking them to appoint an arbitrator? And we chose to go to the SIAC because we knew that within 48 hours we would have a tribunal in place. And that actually happened. The tribunal first passed an order immediately on the application being made, and within a week heard the parties and then granted the injunction. That injunction was then sought to be enforced under the Arbitration Act before the Delhi High Court, which then I think it was Justice Midha who then passed the order first confirming that order, and the matter went all the way to the Supreme Court, where the Supreme Court recognized that even under judicial precedent, I mean, based on judicial precedent, yes, we would recognize emergency arbitrators.
Just to add one more thing, there were two questions raised in that judgment about the maintainability of the appeal against that order. But to that, it has been the apex court has held that the appeal would not be maintainable. The order, though it is enforceable, passed under Section 17, but appeal would not be maintainable.
But there is another slight angle to this, which is material. We had a case where there is an international commercial arbitration seated outside India. Section 9 was moved in the High Court. The court granted interim order. Other side came seeking vacating of that order, relying on Section 9(3), relying on Amazon, that they must go to Singapore SIAC and seek for an emergency arbitral interim direction. What was argued before the High Court, which was ultimately accepted, is Section 2, subsection 2, permits in relation to international commercial arbitration, which is being held outside India, only 3 provisions to be invoked: Section 9, 27, and 37. Section 17 per se is not available at all, and therefore, principle of Amazon would not apply. High Court refused to vacate the interim relief, confirmed it. So it would depend upon the facts of each case as to where the arbitration is being conducted, whether or not Section 9 is always available even in relation to foreign seated arbitration, international commercial arbitration. 17 not being available, the High Court under Section 9 would always have jurisdiction, is the view taken by Delhi High Court, Bombay High Court, followed by a very detailed judgment of Gujarat High Court. That is probably one more angle to this controversy.
Is there anyone from the house who would like to ask any question on this to the learned speakers? Please be free and ask. I mean, you won't get another opportunity like this.
Even if it is in vernacular, I'll help my brother Justice.
No,
So please don't hesitate. If you want to ask in vernacular,
તો મને તો અંગ્રેજી કરતા ગુજરાતી વધારે ફાવે છે.
I
ઠીક નથી.
I understood that, even though I don't understand. Yeah.
in fact, whenever I think I and Saurabh bhai meets, we always start speaking in Gujarati without realizing that my other members.
Section 9 is filed after the arbitration proceedings are commenced. So if you can highlight on that, I think that they might be having this question in mind, but nobody is speaking. So I have to speak on their behalf.
After, like, the Section 9 contains 3 stages: before, during, and after. After the award is passed, but before it is enforced. Now,
I think Mr. Muralidhar would like to say something on this.
mhm.
He has been arguing, now arguing side also. So he has seen all sides.
Here I tend to agree with Saurabh. It's, the courts have tended to take a view that even in a foreign seated arbitration, you can still exercise your section 9 and provided the conditions are met. But I think it is important for the court dealing with section 9 to note the fact, as the question was posed, that a tribunal has been constituted, and to discuss what are the remedies available before such a tribunal in terms of the interim relief granted. Then the question of committee of jurisdictions would arise, because enforcement of that tribunal's interim orders would also become an issue. And the court has to do a balancing act. And I'm not sure it will be so simple for a court here to ignore the constitution of a tribunal abroad in a foreign seated arbitration. And I would urge that all these interim measures should be time bound. It can never be open ended, and you should allow parties to work out their remedies and not foreclose the remedies that they may have before the tribunal, which is a foreign seated arbitration. So this would be my answer.
If
Yes, so
If I could perhaps give one instance to try and attempt to answer the Honorable Chief Justice's question, because it is very relevant. And I think, again, from the perspective of judges to whom such an application may be made, they may be wondering when they should exercise the power, assuming there is a constitution of a tribunal. Now, there are certain instances when you have to grant an ex parte order, and it has to be granted immediately, and it isn't necessary for you to, in fact, even call upon the other side to file a reply, because the assets are, say, going to be fitted away. Very often it can happen, say, in the case where you are concerned that someone is just going to press one button and the bank account is going to transfer all that money. Now, in that scenario, if a party comes and says, my arbitral tribunal, say, even if it is in Ahmedabad, doesn't have its members currently in Ahmedabad, they could be traveling somewhere else, we are not able to get them on BC, but I need that order today or I need it tomorrow, then in such a situation, Section 9 certainly allows you to go to the court. And if you exercise that power, you would be doing it within the contours of Section 9. Now, as Justice Muralidhar said, if the tribunal can come back within a week, maybe 2 weeks, can be constituted, can do a virtual hearing, then certainly you limit the scope of that order for a period of only 2 weeks. So that in the meantime, you've frozen the asset, the tribunal comes back, and the tribunal can then relook at that issue under Section 17. That's one instance in a domestic arbitration where you will be well within your power to exercise your jurisdiction under Section 9 and grant interim relief.
I may also want to add to what Mr. Diwan just mentioned. The Bombay High Court, in fact, has gone one step further and taken the view that an arbitral tribunal does not have the power to pass an ex parte order and it must hear the other party. So they say that, so one exception where you can go directly under 9 would be where you are seeking ex parte relief, but Madras High Court has taken the view that this position is wrong and that the arbitral tribunal does have the power to pass an ex parte order. But they recognize what Mr. Diwan just mentioned now, that in case a tribunal is not in a position to meet, then you can approach the court under 9, get protection to freeze the asset for some time, and then the matter would thereafter be transferred to a 17 and heard under 17.
So would it not be that if, like, once Section 9 is filed during the arbitration proceedings, it would be necessary for the court to ascertain about the availability of arbitral tribunal first and then proceed? Question of granting any ex parte order without ascertaining the availability of tribunal would be frustrating the object of the act. I suppose they have to be sure about it. Because whether ex parte arbitral, if there are two views, that whether ex parte injunction can be granted during the availability of arbitration proceedings, ongoing arbitration proceedings, by the court or by the tribunal or not, then that issue should be, I suppose, should be left open for the tribunal to decide first if the tribunal is available.
That's right. Availability also would mean efficacious.
Correct, correct.
That is it in a position to take it up
Right,
immediately?
right.
So that's why all these have to be time bound. and leaving the parties then to the tribunal when it's constituted and takes.
In the judgment of the SR,
And keeping in mind that the parties may not suffer.
That's right.
so in the judgment of the SR, in one of the paragraphs, it has been mentioned like this, that even after an arbitral tribunal is constituted, there may be myriads of reasons why the arbitral tribunal may not be an efficacious alternative to Section 9(1). This could even be by reason of temporary unavailability of any one of the arbitrators or of an arbitral tribunal by reason of illness, travel, etc. So in such circumstances, Section 9 remedy is available to them.
So in fact, I think that if we go by what the legislative intent is, so 9(3) is very clear. 9(3) says once the arbitral tribunal has been constituted, the court shall not entertain an application under subsection 1. So the general mandate is you will not entertain it. It is only an exception unless the court finds that circumstances exist which may not render the remedy provided under 17 efficacious. Now, to my mind, of course, it would. So it will depend on a case-to-case basis. To my mind, that has to be a very exceptional case, because otherwise it can result in a party, effectively kind of forum shopping. There's an existing arbitral tribunal. You don't want to go there. You come in a Section 9. So unless the court feels that there is, like Nakul said and Justice Muralidhar said, it's a situation where either the tribunal it's not possible for the tribunal to meet, or the members are not there, or there's some logistical problem, or it is something which has to be so emergent, like today something's going to happen, today assets are going to be frittered away, today a bank guarantee is going to be encashed, something like that. Even in those circumstances, if it is like that, then I think the court would have to, even if it's so, it should put it in place just for maybe a few days and tell the tribunal to go ahead and decide it. That would be, I think, that if we are to subscribe to the intent of 9(3). That's my view, but of course it will depend on a case-to-case basis. One has to. Yes, there's someone. Yes,
sir. In that case, can we say that the court has utilized the residuary power when 9(3) is there, and the arbitration tribunal is already there? Then can we say the court has still power of some relief which is a residuary in the nature? Can we pass residuary relief in that case? And a connected question is that whether the court has under Section 9 has a more wider power than the tribunal itself has under Section 17.
I think you see, firstly, so far as residuary is concerned, the concept of a residuary power is something which is not there in the main section. Now,
I'm asking that it is outs the jurisdiction of the court. Therefore, I'm asking.
No, even if the court is exercising power, the court cannot in any case exercise a Section 9 power when an arbitral tribunal is in place unless it falls within 9(3). If it falls within 9(3), it is no longer a residuary power. It is within the statute. So it has to come to a positive finding that there are circumstances which will render the Section 17 inefficacious, and then go ahead to pass the Section 9. So it's within the statute, so we can't call it residuary. And so far as the power is concerned, 9 and 17 more or less are co-equal. So whatever a tribunal can grant under 17, a court can grant under 9. So
may I add one issue?
Yes.
Under Section 9, I'm here, Justice Dhanuka. Section 9 is also invoked sometimes when you want to apply for appointment of court receiver. Because arbitrator has no power to appoint court receiver. Only court can appoint. So in certain events, if 17 is not efficacious as far as appointment of receiver is concerned, you can apply before court under Section 9. That is one part. Second part is that if you want to apply for some interim relief against a third party who is not a party to arbitration agreement, that relief can't be granted by arbitrator under Section 17. But under Section 9, third party also can be injuncted. The example rightly given by Justice the learned chairman, that in case of a third party, in case of a bank guarantee particularly, bank is not a party to arbitration agreement. You want to seek injunction against the bank also. So under Section 9, to that limited extent, you can invoke, go to the court, and after obtaining that, then go to the arbitrator under Section 17.
Sir, actually, interestingly, Nakul and I were just talking about this very issue. After the amendment, there's a specific line in section 17 which says, and the tribunal shall have the same power for making orders as the court has, for the purposes of and in relation to any proceedings before it. And there is a further change in 17(1)(d). 2D, interim injunction or the appointment of a receiver. So now the powers have been equated. So it's possible even for a tribunal, this was what I was asking Nakul. In my view, this is my view.
But sir, court receiver machinery is not available to the arbitrator.
Well, now it is, sir. Now it is. Now it's,
Receiver can be appointed by an arbitrator.
sorry, sir.
Private receiver.
Very well. I mean, that,
Private receiver.
yeah, but you can still go to the tribunal for that relief because the powers have been equated. After the amendment, all that the court can do, it's possible to argue that whatever the court can do, the tribunal can do. It's possible to argue that. No, apart from this, on the bank part, it is possible even for a tribunal to instruct the bank not to release the monies pursuant to an invocation. It's a possible thing even now after the amendment under 17. So although the bank is not a party to the arbitral proceedings, for the purposes of section 17, it will be treated as a party to whom directions can be issued by the tribunal.
There are judgments other way.
No. Post-amendment, sir, I'm pre-amendment, you're right. But post-amendment, the situation has changed, is my submission, of course, subject to what others might say.
Sir.
Either an interim award or an interim order because you are stating the.
It's an interim
party.
order. It's an interim order.
So because let's say bank guarantee not to be invoked at all. So that will go to the main, possibly it touches to the main award. Then what
No, it's still an interim measure. It's an interim measure. It's not an
so it
interim
will
award.
give a color of interim order, not the
No,
interim.
no, to be an interim award, we'll have to go by the Bhadraj decision of Justice Nariman,
Correct.
where he says an interim award is an award which finally decides something
Correct.
during the currency of arbitration,
correct.
like limitation.
Correct.
So if it's an order restraining invocation of a bank guarantee, of course, that has to be subject to all the principles for restraining. It won't be an interim award because it will be subject to further orders.
It's an interim measure.
It's an interim, yes.
Sir, may I?
Actually, just to add to this, we're only talking of bank guarantee. We could have interesting situations. Suppose I know entity A is in the verge of releasing monies to the opponent, like a garnishee order. Can I not restrain? Because the powers are wide.
Under 70.
Yes, and under 9, because they be equated to preserve an asset. Why can't an interim measure of that nature be passed? Nakul is not so sanguine. He says, no, but it only means that these questions might arise before all of you. And, the change in the law is something that you have to account for. The powers under 9 are
I
wide
think we should go to the
and
next
equal
topic.
width has been given to the powers of the
Next
tribunal.
topic, Nathan.
I would take a view that power is always available, whether or not to exercise, it all depends upon the facts. I don't think that we should deny that power to a court because court, in order to give justice, would certainly have that power. Whether facts would demand such a relief at this stage is something which will have to be exercised on the facts of each case.
Now, may I just exercise my prerogative as chair, so to speak, in inverted commas, because we have to proceed. And anyway, Justice Muralidhar will be addressing again on 917. So any remaining questions on 917 can just await that. We'll take them at the end. Otherwise, we'll get stuck at this point. So the second topic for discussion in this panel today is on anti-suit injunctions, which include anti-arbitration injunctions and anti-suit injunctions, for which I am the culprit, since I am the only one who has written a judgment on anti-suit injunctions. So on anti-suit injunctions, the general principles are fairly well known. Actually, calling it an anti-suit injunction is actually a misnomer because you are not restraining a suit per se. And in any case, you cannot restrain an other court of which is not within your jurisdiction from proceeding with a matter. All that the court can do by under what it calls an anti-suit injunction is to restrain a party which is within its jurisdiction from proceeding with a litigation outside its jurisdiction. So it's a restraint given to the party within its jurisdiction. You can never restrain a court. So that's out of the question. We can only restrain a party within its jurisdiction to proceed with a litigation outside jurisdiction if such proceeding is treated as oppressive or vexatious to the proceeding which is within jurisdiction. So if a person has filed a suit before my court and he is simultaneously prosecuting something, or the opposite party is prosecuting something in a court outside, maybe within India or outside India, and that, if it is prosecuted, is going to be oppressive and vexatious to the proceeding before me, then I have the power to restrain the party here from proceeding with that and even to put coercive measures in place. So that's the whole idea of an anti-suit injunction. The same principle, I think, applies to anti-arbitration injunctions if you want to restrain a party from proceeding with an arbitral proceeding outside. Now, the greatest hurdle we face in all such cases is the principle of comity of courts, because you are dealing with especially when you are dealing with a court in a foreign jurisdiction, you are dealing with a court which is completely outside your territorial jurisdiction. You have to keep in mind the fact that that court can say, we are not bothered by your order also. So, and we must be very careful while we pass such an order to see that we are not entrenching on a lawful exercise of jurisdiction by another court, because then it goes against the basic principles of comity of courts. So far as I know, the two major decisions of the Supreme Court on anti-suit injunctions were Modi Entertainment and Dinesh Thakur. And those are, I think, the judgments we lay down. And Nakul would be speaking on this. He is an expert at it. He'll probably tell you all much more about it. I only want to talk about this aspect of anti-suit injunction, though it is trite that one does not speak of one's own judgment. But there was this case I think with your permission, I'll just explain the facts. Yes. So I'll tell you the facts in which this issue came before me when I was sitting in the original side jurisdiction. So it dealt with standard essential patents. Now, standard essential patents, basically speaking, keeping all the technical jargon aside, are basically cases where, suppose, for example, mobiles, they transcend from 2G to 3G, 3G to 4G, 4G to 5G. Now, each time you have a new paradigm coming into play then to make mobiles capable of adjusting to that, you need technology. So if a particular person, a particular entity, like in my case, Interdigital, I think, which was running the Nokia lot, or some big company, they said, we have designed the technology by which mobile phones can operate in 5G. I'm just putting it very broadly. Now, that is called, if that technology is essential for running that phone in 5G, and it is a standard technology, that patent is called a standard essential patent. That's all you need to know for that. Now, unlike normal patents, once you make a patent, you have a monopoly over it for 21 years. But for a standard essential patent, you don't have that monopoly. You don't have it because it is something which is needed all over the world for anyone to operate in that particular 5G jurisdiction. So you have to make that patent available to any licensee who is willing to take it from you for a fee which is called fair, reasonable, and non-discriminatory. So it's called FRAND. So for a FRAND rate, any person who has developed a patent, an SEP, a standard essential patent, should be willing to allow a person to use that patent, a licensee, for a rate which is FRAND. So in all these SEP infringement cases which come before us, the normal plea that is taken is, I have this SEP, I am the one who has developed it, Mr. X is using it in his phone, I am willing to give him a license at a particular rate which is FRAND, he is not willing to accept that rate, so stop him from using it. That is the general trend of these cases. So two aspects arise in all these cases. One is of infringement, and second, whether the rate you are offering is FRAND. Now, a FRAND rate is global. So what happened before me was, one person, Interdigital, came before me saying, we've developed a technology, Xiaomi, which is running these MI phones, Redmi phones, etc. They are using this technology. This is an SEP technology. My patent is a standard essential patent. I am willing to give it to him for a FRAND rate. He's not willing to take it. So you please stop him. So while that suit was going on, the Xiaomi moved a court in Wuhan, a district court in Wuhan, and believe me, I wasn't influenced by the fact that this was mid-COVID, but they moved the court in Wuhan, and they moved the court in Wuhan saying, please fix a global FRAND rate. And
Or nicer note, you could have called it ultra virus.
And the Wuhan Code took it up. The Wuhan Code took it up. They had the right to take it up, and they took up that suit for fixing a global FRAND rate. But in that, they moved an application saying, "You please restrain Interdigital from prosecuting the suit in India." So the Wuhan Court gave an anti-suit injunction restraining the plaintiff before me from prosecuting his suit, and against that, the Indian plaintiff came saying, "Please restrain the enforcement of their anti-suit injunction." So I had no precedent with me. I don't know. And we had 3 days to pass the judgment. I rate it as the most difficult case I decided. And because the Wuhan court said that in 3 days, if he doesn't withdraw his Indian suit, he will be subjected to some $100 million fine or something like that. So we had to pass this within 3 days, and that's how that order came to be passed. So I'm just giving the facts because I shouldn't say more about it. It's my own judgment. Nakul will speak about it. But these are the general issues which arise in anti-suit injunctions, anti-arbitration injunctions, anti-enforcement injunctions. And now I think I'll leave the floor to Nakul to proceed with it.
The Honorable, the Chief Justice, Honorable Judges of the High Court, Honorable other judges who are here, my fellow members at the bar.
I know, but we.
The reason why I have taken this liberty of standing at the podium is because our Guru, who's been referred to more than once today, suggested that I should come to the podium and speak. And I will start with a bit of a contradiction only because you've heard Justice Hari Shankar in the Interdigital case. So I think if there is an expert on anti-suit injunctions, it is Justice Hari Shankar who has actually decided that issue. Which I must tell you, when Justice Muralidhar and I were just having a brief conversation when this was going on, he said, you know, this in many ways is like a sir rejoinder. And I couldn't agree with that anymore. But anyway, just coming back to this, I think Justice Hari Shankar has summed this up very well. Let me just open up what an anti-suit injunction is, and then I'm going to deal with 3 different aspects of an anti-suit injunction which arise in the context that we see in a lot of commercial courts. So, as Justice Hari Shankar said, an anti-suit injunction is a case which is filed. It's filed under the Civil Procedure Code of, and it could be in India under the CPC. It could be in other jurisdictions under their civil procedure rules, restraining a party from prosecuting another civil proceeding or another legal proceeding in another jurisdiction. So the cause of action for an anti-suit injunction has to be made out to say why the opposing party, which is the defendant, should not be allowed to prosecute a proceeding in another forum. Now, that forum could be a foreign court. And when I say foreign court, it doesn't necessarily have to be a court outside of, the territorial jurisdictions of a country. Someone could come to a court, hypothetically could come to the court in, say the Delhi High Court and say, sorry, restrain somebody from proceeding with a proceeding in Gujarat. And I'll tell you, why that situation may arise. Or it could also be restraining a party from prosecuting a case outside of the territorial jurisdiction. The restraint is on the party. It is never on the court. And one of the reasons why that is done is because I think we've all followed the principles of comity of court. So one court does not injunct another court. You injunct the party. So if you ever get a plaint which makes a reference seeking an injunction restraining a court from proceeding, then more often than not, the judges will tell you that is not the relief we will grant. We will only restrain the party from proceeding. And that effectively is as good a remedy as that you will need, because we are here concerned with the party. So that's one part of it. The second part is, where does all of this come from? Yes, the concept of anti-suit injunctions evolved in England. And certainly when it evolved 400 years ago, it was in the context of court proceedings versus court proceedings. But in today's context, what is relevant is is that in arbitrations, when do courts proceed to grant such injunctions? Now, let me tell you that it is used very, very often in the courts of UK. And the reason I'm going to start with that example is because I think it's going to become very relevant even as far as India is concerned in the times to come. And very often parties signed up to arbitration clauses saying our seat of arbitration is London, and there could be parties from all over the world. What a party would do is that in order to avoid going to arbitration, it would file a civil proceeding within its home jurisdiction. There were multiple cases where Indian parties would do that, ask a court within its territory to exercise jurisdiction based on the cause of action. And it wasn't just Indian parties. I mean, there were parties from Russia, there were parties from other places. So the application that went to an English High Court was very simple. There is an arbitration agreement between the plaintiff and the defendant. That arbitration agreement provides for arbitration in London. The defendant is either likely to or has commenced a proceeding outside within their home jurisdiction. That is in breach of the arbitration agreement, and therefore restrain that party from breaching the arbitration agreement and proceeding with the proceeding within their home jurisdiction. And English courts routinely granted that order despite the fact that the defendant was not within its territorial jurisdiction. It did it on the basis that because the seat of arbitration was London, and because it had the right to enforce an arbitration agreement, it was entitled to exercise jurisdiction and pass such an order. Now, why that becomes important is because if I was to now break up anti-suit injunctions into three spheres, you are looking at either an anti-suit injunction, where you are looking at restraining a particular suit which is being filed outside of jurisdiction. Now, that could happen in multiple spheres. The seminal judgment of the Indian Supreme Court is in a case called Modi Entertainment. It's a 2003 judgment, and it lays down 10 principles. The fundamental principle that it lays down is that the party against whom you're seeking an anti-suit injunction must be within the territorial jurisdiction of the court. Now you see that there's a difference between English law and Indian law on this point. And if you don't have that party within jurisdiction, then you will not pass such an order. Now, the reason for that is because if you pass such an order, then you can also initiate contempt proceedings against the party if it violates your order. So that's one critical aspect. Two, Modi Entertainment requires that, the principles of comity, which Justice Harishankar also mentioned about, will come into play. Three, it makes a very interesting point. It says if more than one forum is an appropriate forum, then you will ascertain why you as a court should grant the injunction, because if a party has gone to another forum which may be equally appropriate, you can go, certainly allow them to go there. But four, it actually laid down the principle of oppressiveness and vexatious. So an anti-suit injunction can be granted if you think that somebody is going to start proceedings against the plaintiff in various jurisdictions, sometimes more than one, because of basically dragging the counterparty to multiple litigations. You certainly want to avoid that. And that is why, I'm not giving you all of the 10 principles. That is the basis that you adopt when you've been faced with a case where there's an anti-suit injunction. Now, let's translate this into the context of arbitration. Very often, in fact, there are suits which are filed. And when these suits are filed, seeking some relief, the other party comes to you and says, I'm filing a Section 8 application under the Arbitration Act. Stop the suit from proceeding and let the matter go to arbitration. Now, at a point of time, like what do you do? Section 8 certainly tells you that unless the arbitration agreement is null and void, you will refer the party to arbitration. So it's got a very strict approach on what a court can do. And more often than not, courts take the view that they must refer the matter to arbitration. But if the other party can show that the arbitration proceeding itself could never have been commenced, for two reasons. One, because there is in fact no arbitration agreement in existence, or if there are other reasons where, say, a dispute has anyway been fully adjudicated and there is nothing more that survives, then certainly a court will consider whether or not an anti-arbitration injunction should be granted. And again, courts are very, very skeptical. So there was a case which went to the Delhi High Court, where an arbitration in Singapore had been commenced. The counterparty filed a suit in the Delhi High Court saying restrain the party from proceeding with arbitration in Singapore because it is very expensive and because we are telling you that the issue has been ventilated. So the issue broadly was that will res judicata apply? And the matter came up before Justice Shakhtar when he was sitting as a single judge of the Delhi High Court. And what Justice Shakhtar said was, no, I will not restrain the party from proceeding with the arbitration in Singapore for two reasons. One, the issue of whether it is res judicata has to be decided by the tribunal. It is not for the court to make that decision and pass an anti-arbitration injunction. And two, said, as far as the costs are concerned, that cannot be a basis to grant the anti-arbitration injunction because parties in their contract have agreed to arbitrate outside of India. And that principle, again, he borrowed from Modi Entertainment, which had taken the same view that if a party has agreed to the exclusive jurisdiction of either a court or an arbitral tribunal, then a court must respect that. Now, if you were to look at these two scenarios, when else can a court be asked to consider whether they should grant an anti-arbitration injunction? I'm going to give you an example of a case where the Delhi High Court has refused to grant an anti-arbitration injunction, but there is a challenge which is now pending in the Supreme Court. And I'm therefore not going to give you any definitive conclusion on whether the High Court is right or not. There was an Indian party which had entered into a contract with a foreign shipping company. The vessel blew up and there was a significant loss that had been sustained. The Indian party chose to go to a Panamanian court because the ship was registered in Panama and file civil proceedings in Panama. The foreign party obviously was very happy that the Indian party had come to its home jurisdiction. It participated in the proceedings. This is despite the fact that the Indian party could have commenced arbitration in India. So, after proceedings got underway in the Panamanian court, the Indian party decided it now wanted to commence arbitration. And an anti-arbitration injunction suit was filed in the Delhi High Court. And the Delhi High Court said, no, we are not going to go into this issue. We will let the arbitral tribunal decide whether there has been an abandonment of the arbitration agreement by the filing of the Panamanian proceedings. So again, what you see is judicial restraint in restraining a proceeding because these injunctions are not used very often. But the point is that does an issue as far as abandonment of a particular contractual remedy fall within the domain of the court or does it fall within the domain of the tribunal? And the Delhi High Court took the view that it fell within the domain of the tribunal and did not grant that injunction. Again, I'm leaving the question open because the matter is now pending before the Supreme Court. So I don't want to say anything more than that on this issue. The last issue which arises, which really comes into play when in the interdigital case, is the one which Justice Hari Shankar spoke about. And what, in my view, a court needs to see is whether there is a cat and mouse game going on here. Our party is misusing the court in order to try and benefit. And that is where the anti-suit injunction principles come into play. As Justice Hari Shankar pointed out, a party filed the suit in India before the Delhi High Court. The other party went to China in Wuhan and filed an anti-suit injunction, which was certainly granted. And there were certainly precipitative orders which were granted, and the matter came back to the Delhi High Court. And if you see that there's a cat and mouse game being played, if you see parties trying to misutilize a particular forum for their own benefit, then certainly you will be circumspect to that, and you will certainly take that into account in determining whether or not you want to grant the anti-suit injunction. At the end of the day, the large principle which arises in my view is this. If a party is violating its contractual obligation and filing a proceeding in a forum which it considers convenient or it considers beneficial for reasons which have nothing to do with the merit of the matter or the agreement between the parties, then certainly there is a basis for a court to restrain that party from going ahead with those proceedings. And I think that overarching principle applies whether it's an anti-suit injunction, whether it is an anti-arbitration injunction, or whether it's an anti-sir rejoinder injunction, which the court has to grant. Thank you.
I think Justice Muralidhar would like to supplement this.
No, I was only wondering when committee of jurisdictions, it's more like a question to Nakul. Is there something of a distinction between common law jurisdictions, non-common law jurisdictions? And how do courts respond to, when they're faced with this is an order of this country's court? It could be from a particular region in the world. And do these things matter? Because of the understanding of rules of people in that particular country, it goes beyond mere legality, doesn't it?
The reality is that it does. I mean, much that I would like to say that it doesn't, the reality is that it does. We are more likely to recognize an order which has been passed by a court which we believe would have considered matters from an objective perspective before having passed that order. This Justice Muralidhar has put me in a big spot because I certainly can't be critical of courts, as opposed to courts which we believe may not necessarily have applied the relevant principles. So I'll give you an example. Very often there are courts which have disregarded orders that have been passed by other courts. And again, they need to find a legal basis for it. They cannot just be critical of that foreign court. So the way they look at it is to say, well, the principles that are set out have not been complied with, and hence we don't recognize that order. But yes, the reality is that if you say get an order from a court in, say, the United Kingdom, or you get an order from the court in Singapore, you're more likely to take the view that all the relevant aspects have been considered. Whether that's the correct approach, I think, is better suited for either Justice Muralidhar. It's probably best suited for Justice Muralidhar to answer, given his previous avatar.
So we have one question which has come from one of our online viewers, which is as to whether a suit which merely claims a relief of anti-suit or anti-arbitration injunction would be maintainable. Can you address on that?
So I would say yes. What would say, let's just put it, what would be the basis for an anti-suit or an anti-arbitration injunction? So if I was to take anti-arbitration injunction, it would be, my cause of action would be breach of an arbitration agreement. And therefore, I will say the defendant should not be allowed to brief its contractual obligation to arbitrate. And therefore, I seek that as my final declaration. In the meanwhile, please restrain the defendant from going ahead with a particular proceeding. And similarly, when it comes to an anti-suit injunction, if supposing there is an exclusive jurisdiction clause. So let's assume that there is an exclusive jurisdiction clause between parties with, say, jurisdiction of New Delhi, courts in Delhi. And if a proceeding is filed, say, in the courts in Ahmedabad or somewhere in Gujarat, can a party come in, say, to the Delhi High Court and say, please restrain them from proceeding in Gujarat because there is an exclusive jurisdiction clause in the courts in Delhi? And if you go by Modi Entertainment, the answer to that appears to be yes.
Just to follow up on that. So it's, I think, very important that the person against whom the injunction is sought has either been served or has submitted to your jurisdiction. Because it would be not wise to pass this as an ex parte order.
I agree with you. In fact, that was the first principle which I had highlighted from Modi Entertainment. the part defendant against whom an anti-suit or an anti-arbitration injunction is being sought should be amenable to your own to your jurisdiction.
But that would raise an interesting issue. When you say within your jurisdiction, do you mean territorial jurisdiction or otherwise? The reason being, let me give you an example. Way before Modi, somewhere in the year 2000, 2001, in a proceeding for sanction of a scheme under Section 391 of the Companies Act, when one of the creditors was in London and had filed a suit, Section 391(6) application cannot be maintained because proceedings are in London. So anti-suit injunction was asked for against the English party, preventing the party from proceeding with the suit. The High Court ex parte granted it. Ultimately, matter did not go to its logical end because the party agreed to the injunction, did not pursue with the suit. Scheme was sanctioned. The claim was ultimately settled. Matter got over. Therefore, the issue has not been ultimately adjudicated. But in a situation when the scheme proceedings are being filed, every creditor of the company would be, in that sense, within the jurisdiction of that particular court, High Court. But therefore, my question is, when we say jurisdiction, do you only mean territorial jurisdiction or do you also mean jurisdiction which is encompassed in those court proceedings, maybe beyond territorial jurisdiction?
So if I was to read Modi strictly, I think it would be territorial, but as Justice Muralidhar just said, if you will be amenable, say by submitting to jurisdiction, which in a case like yours will be because you're a creditor of a company where the scheme is being considered within a particular jurisdiction, then well, you may well be able to extend those principles.
I want to add one more comment on the topic, something that I thought may be of relevance to the audience. If a suit is filed for an anti-arbitration injunction, now what is it that a defendant does? A defendant would, one, file a counter to the application relying upon the Modi entertainment principles as to why an injunction should not be granted. But it is also likely that the defendant would file an application under Section 45 of the Arbitration and Conciliation Act, pointing out that there is in fact a valid arbitration clause, and hence the matter must be referred to arbitration. So when you look at anti-arbitration injunction, it is also important to keep in mind the scope of Section 45, because that's often an issue that comes up. And while deciding an application under Section 45, you will have to decide whether prima facie there is a valid arbitration agreement that is in force. The words used are whether the arbitration agreement is prima facie. Sorry, I have to read it out. Unless it prima facie finds that the said agreement is null and void, inoperative, or incapable of being performed. So, while deciding this application, you will have to go into whether or not there is a valid arbitration agreement. Let me give you an example. A and B enter into a transaction. A is based out of Bhavnagar. B is a party that's based somewhere else. There is an arbitration that provides for arbitration in London. There's an arbitration clause that says arbitration seated in London. B invokes arbitration. A files a suit before the Bhavnagar District Court saying that the arbitration clause today is not valid or not operative for some reason. Say prior to the judgment in PASL, one live example that came up was there was an arbitration clause that provided for arbitration between two Indian parties, and an anti-arbitration injunction was filed on the basis that that two Indian parties cannot have a seat of arbitration outside India. There had been prior precedent where the Bombay High Court had accepted such a view. On this basis, an injunction was granted. So then the other party filed a Section 45 on the basis that today there is a valid arbitration agreement and that two Indian parties can have a foreign seat. On that basis, if such an application is filed and the court finds that prima facie there is a valid arbitration agreement, the entire suit will have to be thrown out. The entire matter will have to be referred to arbitration. So that's something to keep in mind.
Anything in from the house? Yeah, we'll go on to the next topic then. In the end, if there's still time left, we will allow questions even on the topics which have been covered. So the third topic is of statutory arbitrations. Now, this is honestly a subject of which I am not very much aware. In fact, I have not come across any matter involving statutory arbitrations during my tenure on the original site. But in the statutory arbitrations now are recognized in section 2(4) of the Arbitration Conciliation Act. And the normal issues that arise for in the case of statutory arbitrations are the conflict which would arise if there is an arbitration clause in the contract between the parties and a statutory arbitration because the parties happen to be subject to a particular statutory regime. So there is a recent decision of the Supreme Court of 2025 in Umri Poof Partapur Turbes, where I think that may be one of the points on which Mr. Suparkar would be speaking, which seems to have taken a view that a party cannot ignore a statutory arbitral mandate even if there is a contractual arbitration clause between the parties. There are some scholars who have a view that may be correct, whether it's correct or not, but that's the latest decision of the Supreme Court as far as I see on this point. Then the other issues that arise in the context of statutory arbitrations are the applicability of section 17 to statutory arbitrations, whether interim relief could be granted otherwise, and whether statutory arbitrations are actually violative of party autonomy, because when the statute was enacted, the parties are not parties to the enactment. So if the parties come to a contract in which they have a particular arbitral regime and there is a statutory arbitral regime to which they are not parties, then does it binding them to statutory arbitration, does it violate the principle of party autonomy? And similarly, the aspect of consent. So can parties, even if they are by consent, they desire to go in for contractual arbitration, can they be forced to subscribe to the statutory arbitration principle? Then the last issue that may arise in these questions is, can an award which is passed, let us say, as per the contract between the parties, can it be set aside in 34 on the ground that there is a statutory arbitral mechanism which was never followed? So these are all aspects which arise in the context of statutory arbitrations. Mr. Suparkar, we will throw the floor to you.
Thank you very much. At the outset, let me thank the Chief Justice and other honorable judges for giving me this opportunity to share some of my thoughts on the interesting topic. When the members of the panel were distributing the topic as a residuary legatee, I got the topic of statutory arbitration. So I was very happy that probably I may not have to speak much. I was allotted 10 minutes. I thought I may hardly go for 5 minutes. But when I started looking up to the topic, I find there are interesting nuances, interesting aspects which need to be discussed. I find there are broadly three different kinds of statutory arbitrations. One, where the statute provides, number one, compulsory arbitration. Number two, how the award will be enforced. Number three, exclusion of jurisdiction of civil court in all dispute matters. So in those matters, the jurisdiction of civil court is completely barred and the parties will have to litigate only under the statutory arbitration. Let me take one simple example. We have Gujarat Public Works Contract Disputes Arbitration Tribunal Act. Under this provision, under this act, there is a definition of works contract. Now, whenever there is a dispute between the parties in relation to works contract, the act says you shall have to make a reference to the arbitral tribunal set up under the statute. Under section 8, the power is given to the tribunal to give award both interim and final. The provisions of section 12 expressly state that against the award of the tribunal, the only remedy is by way of an application to High Court. The scope of the application is analogous to section 115 of the CPC,
namely to exercise jurisdiction not vested in law or failed to exercise jurisdiction vested or has acted in its jurisdiction illegally or with material irregularity. That's the only forum. And more precisely, section 13 specifically prohibits civil court from entertaining any dispute covered under this act. The sequitur of this discussion is, if at all a dispute comes to the civil court, including by way of an application under section 9, in relation to matters covered under this act, the civil court would have no jurisdiction and it has to be hands-off approach. Let's take it scenario number 2. Under bylaws made under the provision of Security Contract Regulations Act, all disputes between the broker and its clients are required to be referred to a statutory arbitration. That will be arbitral tribunal panel set up by the stock exchanges. Disputes are adjudicated there. But then the matter ends there. There is no further provision in the relation to enforcement or challenge. If that be the situation, once award is given by that arbitral tribunal, the challenge will be under section 34 to the civil court. There can be an application for stay of the money part of the award under section 36, and the civil court will have to take into consideration principles under section 36(3) of the Arbitration Act, read with the provisions of CPC, as to whether or not to grant stay. And then against the order of the civil court under section 34, appeal will lie to the High Court. Therefore, scenario number 2, the statutory arbitration provides only for the arbitration conduct, nothing beyond that. We have third scenario, and that is, for example, MSME Act, Micro, Small and Medium Enterprise Development Act. Under this act, section 18 provides that there is an MSME council, and an MSME which has a dispute with its debtor can make a reference to MSME council. MSME council will first try to conciliate the proceedings. If conciliation proceedings fail, then MSME council itself will take up arbitration. The award will be given by that MSME council. Now, over here also, post award, what is to be done is not stated, except, I'll go to exception a little later. In other words, once the award is passed, then you will have a right to challenge before the civil court under section 34 and then second appeal under section 37. But then comes catch. The catch being under section 19 of the Act, 19 of MSME Act. No application to challenge the award of MSME council will be entertained by a court unless 75% of the decretal amount is deposited in the court. And second, proviso to section 19 says the court shall, pending the hearing of the application, on such terms as it deems it appropriate, release the money in favor of the award holder or decree holder. This would mean that whereas machinery of section 34 is the machinery which is being applied to challenge the award, the role of the civil court under section 34 is circumscribed by section 19 of MSME Act. Section 2 clause 4 read with section 2 clause 5 of the Arbitration Act, they prescribe that if there is a provision of law which overrides Arbitration Act, then that provision of law will have to be mandatorily followed. And therefore, in an award which arises out of MSME Act, the civil court will not entertain any application unless 75% of the amount is deposited. Interesting question of law can arise. Section 34 application has to be filed within 90 days with the possibility of condonation of delay by 30 more days, but not beyond 120 days. Application is filed within 90 days. Monies are not deposited within 90 days. Monies are deposited on, let's say, 131st day. Would, in such a situation, the term court shall not entertain, apply, and the application will be rejected, or entertainment is prohibition against the learned judge, not the registry in accepting the application. The reason why I discuss these three scenarios is, it is not as if Section 34 court or the district court has completely hands-off approach in statutory arbitrations. Whenever an application is made under Section 9, before arbitration, or under Section 34 post arbitration, in relation to statutory arbitrations, the court will have to find out for itself to what extent I have jurisdiction. Is it that the statute circumscribes my jurisdiction? If yes, the court will have to go by that circumscribed jurisdiction. But if there is no such prohibition on the power of the court, like my second example, award of the panel of the stock exchange, then full powers of Section 34 will have to be exercised. Having said this, the couple of issues raised by the learned chairman. Number one, where the jurisdiction of the civil court is completely excluded, like the provisions of the Public Works Contract Dispute Arbitral Tribunal Act, where will the contractor go? Civil court will not be able to help him. Supreme Court in 2022 SCC, Amber Industries has said that only the tribunal can give relief under Section 17 of the Act. And therefore, in such a situation, the power is not available to civil court under Section 9 for the simple reason that jurisdiction of civil court is completely barred. That takes me to the second issue about party autonomy and whether or not award passed in defiance of or in ignorance of the provisions of statutory arbitration, whether that is valid or not. Let me take the first possible scenario. Award passed in ignorance of the bar of the statutory arbitration. This issue has gone back and forth, even at the highest level. The latest word on this appears to be, there are two judgments of Supreme Court on this issue. One of 15th May 25 in the matter of Gayatri, and another of 30th July 25 in the matter of Umri Poo, Pratappur, both by the same combination of learned judges. And the principles appear to be this. One, if there is a statutory arbitration which prohibits parties to go to private arbitration, then even if the agreement provides that you have a right to go for private arbitration, such a clause is invalid. At some point of time, courts had taken a view that statutory arbitration is mandated only when there is no arbitration clause in the agreement. If arbitration clause is contained in the agreement, statutory arbitration would not apply. Now Supreme Court has very clearly stated, once there is a statutory arbitration, whether or not there is an arbitration clause, you shall necessarily follow the path of statutory arbitration. Two, but you do not follow that path. You do not follow that path because neither party is aware of that particular path, or the party is aware, it chooses not to raise that argument. Ultimately, award is passed without there being any objection before the learned arbitrator that, sir, you have no jurisdiction by virtue of the fact that there is a statutory arbitration. Would you be able to take that objection under Section 34 that, sir, the tribunal is wholly without jurisdiction? Now there, Supreme Court in this 2025 Umri Poo has taken a view that if the parties have permitted arbitration proceedings to go forward without raising any objection, and if thereafter the award is passed, then in barring exceptional situations, the court will not entertain objection under section 34 of the Act. The court puts it almost as waiver. Now, I am aware that statutory right cannot be waived, but if it is a private right not in the public interest, it can be waived. Supreme Court has not examined the issue in detail from it being a private right or a public right. But in this Umripu, Supreme Court has said, if parties have permitted arbitration to go ahead without any objection, then under section 34, you would not be permitted to raise that argument. If you had raised that argument under section 16 or otherwise, and learned arbitrator decided against you, and then if the matter is carried under section 34, this judgment will have no application. But even there, Supreme Court has struck a discordant note by stating that at some point of time there was some confusion as to whether or not statutory arbitration will override contractual arbitration. So at a time when the view was that it is possible to go for contractual arbitration, it may still be open to you to make that particular argument. But then those days are gone, and essentially the dispute was all in relation to Madhya Pradesh Public Works Act. So far as Gujarat is concerned, the law is very clear. We have always been taking a view that statutory arbitration would prevail. And therefore, let me summarize by this. If an application comes under section 9, because the district courts would be having section 9 application and section 34 application, section 9, one will have to be sure that its jurisdiction is not ousted. If it is ousted, hands off. If it is not ousted, then obviously principles of section 9 for the purpose of grant of interim order. Section 34, again, whether or not under the statutory arbitration under the respective act, whether there is a complete bar of civil court entertaining a dispute or a challenge, then again hands off. Otherwise, principles available under section 34 will have to be invoked and appropriate relief may have to be granted. That's all. Thank you very much.
This is already answered. Any questions from the audience? Yes. Yes, madam.
Hello, sir.
Yes.
This is to Saurabh, sir. Saurabh, sir, in this Gujarat Public Works Contracts Arbitration Act, so this act provides that if it's a works contract, the dispute has to go to the Public Works Arbitral Tribunal. So in that case, my question is that who has the authority to decide whether this is a works contract or not? Whether my contract is a works contract, this question has to be decided. Can it be decided by Section 11 court, like by the court who's exercising Section 11 jurisdiction, or by the tribunal itself?
Okay. First of all, am I audible? Okay. First of all, I think I'm not audible. Yeah, okay. First of all, as a party, I have to take a call. Okay. As a party, I have to take a call as to whether or not my case is covered under the Public Works Act. If I believe it is not covered, and if I want arbitration, I may go under Section 11. It's open to other side to come forward and say, sir, please do not appoint arbitrator, because the provision of Arbitration Act 1996 are not applicable. This is governed by the Public Works Act. If the court upholds that contention, then obviously the matter will go there. Interesting question might arise if the court rejects that and accepts Section 11 reference application. Then arbitral tribunal decides the matter. Would Section 34 again be available at that stage on this ground? Or can it be argued that between the parties, issue has attained finality, res judicata, and party having not challenged the order of reference under Section 11 may not be then permitted to raise this issue again under Section 34. But probably yes. But if the learned judge, while exercising power under Section 11, has kept that issue open by saying that you can move under Section 16 to the arbitral tribunal will take a call as to whether or not it falls within the within the definition of works contract. And if arbitral tribunal takes the view, if it is a wrong view, then under section 34, it can always be challenged. So it will all depend upon the language of section 11, whether the court has concluded the issue at that stage. If it is concluded, matter is over. If it is not concluded, then it will be again left to the arbitral tribunal and then challenge under 34, 37 SLP.
Thank you, sir. Sir, namaste to honorable dignitaries and our Chief Justice Srimati Sunita Agarwal for taking me under her wing. My simple question is relating to section 14, restraint of the judge. Yes, sir, and also 34. My question is in injunction and the time period under 29A. So if under time period it is up till 18 months, it can be extended up till 18 months, then could it not be a tactic that to give injunction and extend it to 18 months?
Actually, Anirudh would be speaking on that. He'll answer after he's given his address. Otherwise,
Yes,
we'll,
sir.
so then we'll go on to the fourth topic for discussion today, which is on 14, 15 and 29A. I'll be a little briefer. 29A actually was actually in the Delhi High Court, we have an original side. So all judges on the original side always used to wish that they get 29A petitions because it's first class disposal, first day, first hour, within 5 minutes, case disposed of. All we used to ask was, how much time do you want? When was the mandate over? Disposed of. And both sides used to say, this is all. But now even 29A, I believe, is getting subject matter of debate. So now the whole paradigm seems to have changed. So the issues that come up under 14, 15 and 29A are well understood. I mean, they are the 14, 15 talks about de jure, incapability to act and failure to act without delay. So one of the issues is, what is the concept of delay? How much delay should be treated as undue delay so as to empower a court to substitute the arbitrator? Then the question is, the second part of it says withdraws or terminated by mutual consent. Now, can both parties just come to the court and say by mutual consent, we don't want this arbitrator to continue? Or do they not have to provide some reasons as to why they don't want him to continue? And so that becomes another issue which comes up under section 14. Now, when we come to section 15, my personal view is section 15.1 is actually a legislative superfluity because it just reiterates what is there in 14. It says if a party withdraws from the mandate or if the mandate is terminated, then the court can appoint a substitute arbitrator, which is exactly what 14 says. So 15.1 is just 14 in reiteration. 15.2 goes on to say that the court can then appoint a substitute arbitrator. Then one of the issues that arises, it says according to the rules applicable. Now, according to the rules applicable has been interpreted by the Supreme Court to mean the clauses arbitration agreement between the parties. So actually the word rules is a little misnomer. Court has said rules means the arbitration agreement between the parties. Now then one issue which comes up frequently before courts, at least in Delhi, is whether then it goes back to the section 21 stage. Do the parties then again have to issue a section 21 notice and start from that stage, or can it start from the stage we presume that just a substitute arbitrator is appointed? That's another issue which will arise. So these are all the points which come up with 14 and 15 too. So far as 29A is concerned, 29A now has become extremely cumbersome because 29A, if you go to 29A itself, it has so many provisions now which say that 29A4 says, if the award is not made within the period under subsection 1, court can extend the period. And then it goes on to say that provided that if the court finds proceedings have been delayed for reasons attributable to the arbitral tribunal, then it may order reduction of fees by not exceeding 5%, etc., etc. So the whole thing is now the arbitral tribunal comes into the question, into the fray, and the third proviso says you will hear the arbitrator before passing an order under this provision, which becomes a very embarrassing situation in many cases. Then it comes to 29A5 says extension of period under subsection 4 may be granted on the application of the parties only for sufficient cause and on terms. Then what is sufficient cause? That again becomes a subject matter of dispute, because sometimes the parties come forward, court cannot straight away just extend the mandate. Now court has to say there is sufficient cause. This is the reason why I treat the cause as sufficient. So the extent to which, even if the parties want the mandate to be extended, does the court still have to go forward and say that I find there is sufficient cause to extend it, or can it just say that, well, the parties want it extended, so we are extending the mandate? That becomes an issue. Then when it comes to 29A6, this is another very thorny provision which is now coming up in many cases before the Delhi High Court for consideration. While extending the period under subsection 4, it shall be open to the court to substitute one or all of the arbitrators. And then it goes on to say what if they are substituted. Now, when does the court substitute the arbitrator? There are no guidelines in 29A6. Is it because the court feels that they are delaying proceedings, or is it because the court feels, I mean, there is absolutely no guideline. So it is completely uncanalized as to when the court can actually substitute an arbitrator. Can the parties just come to the court and say, we want an arbitrator substituted and extension of mandate? Will the court just agree to it? So these are all issues which are now arising in the context of 14, 15 and 29A. Now I'll give the floor to Mr. Krishnan. He'll just enlighten us on these. So many cases are coming in 29.
Thank you, sir, and thank you to the Honorable Chief Justice, Honorable Judges of the Gujarat High Court, especially Justice Pranav Trivedi, who've invited me to be here before all of you. It's an honor. I may not be in a position to deal with all the issues because there are so many issues that are there, but I thought, given that I'm addressing the district judiciary by and large, I would set out specific scenarios that arise in the context of section 14, 15 and 29A and try and answer them. Scenario number 1. Contract provides that contract between A and B, contract provides that A shall unilaterally appoint an arbitrator. B approaches the court under section 14 and says terminate the mandate of the arbitrator. The person appointed is not otherwise conflicted. The person is, say, a retired judge, not otherwise conflicted by the 7th schedule. What do you do as a court hearing this matter? I will give the answer and then I will give the reasons. Answer is you terminate the mandate. The reasons is a threefold. Rather, there are 3 limbs to it. Limb number 1, as Justice Harishankar mentioned, de jure incapability is a ground to terminate the mandate. Number 2, what is de jure incapability? The Supreme Court in HRD versus Gale has equated this to ineligibility of the arbitrator. And ineligibility would include a scenario where the arbitrator and the relationship between the arbitrator and the parties or counsel fall within the ambit of the 7th schedule read with section 12.5. Therefore, going by HRD versus Gale, if the arbitrator is hit by the 7th schedule, then there is an automatic ineligibility and the parties can approach court, or rather the party aggrieved can approach court under section 14 for termination of mandate. But will this extend to a unilateral appointment? There have been several case laws starting from TRF, Perkins, Bharat Broadband, and finally the Constitution Bench in Core. It started off by way of a bit of a judicial fiction, where the Honorable Supreme Court said that if you are not entitled to act as an arbitrator, then you are not entitled to appoint an arbitrator as well. This was further extended to be automatically falling within the ambit of a 7th schedule violation in Bharat Broadband. Now, going by this test, if a party unilaterally appoints an arbitrator, then it is deemed to be a 7th schedule violation independent of the qualifications of the arbitrator or whether he or she actually fell within the 7th schedule. So going by this logic today, if there is a unilateral appointment of an arbitrator by a party, the other party is entitled to terminate the mandate. Now let me tweak this a little. What if there is participation during the process? What if the parties file their pleadings, go into the stage of evidence, 8 months into the proceedings, this section 14 is filed. Now, even in such a scenario, unless there is an express waiver in writing between the parties, the mandate ought to be terminated. And the reasoning for this is this. Ordinarily, you would have come across the section 4 standard of waiver, which would be implied waiver. So waiver by conduct would come within the section 4 standard of waiver. But here we're looking at section 12.5 and the proviso to section 12.5, which says that in order to waive this, you need an express waiver in writing between the parties after the dispute has arisen. Therefore, the standard is much higher. So even if there is participation, unless there is express waiver, the mandate will have to be terminated. Scenario, I'm going to tweak this further. Now, parties file a joint memo under section 29A, extending the mandate by 6 months. And then a party approaches court under section 14. Will signing of the joint memo amount to an express waiver in writing? Today, it's arguable that, court doesn't directly address this in the context of 29A. There are 2 High Court judgments that are contrary. The Madras High Court takes the view, the division bench of the Madras High Court takes the view that signing of a joint memo under 29A will amount to an express waiver in writing. The Delhi High Court takes the view that it will not, because for an express waiver, the right has to be pointed out to the party, and then the party has to waive it. I think with respect, I may agree with the Delhi view on this. So, but it's not been decided at the Supreme Court level. So these are the issues that arise in relation to unilateral appointment. Now let me tweak it a bit more. What is a scenario where one party, the clause says contract between A and B, A will set out 5 names from which B has to select the arbitrator. B goes ahead and challenges this, but B selects an arbitrator. Thereafter, arbitration begins, and then B files a petition under section 4 challenging the mandate. Will this be hit? Will this result in a 12.5 and 7 schedule violation or not? Now, initially, the Honorable Supreme Court in West-Alpine had permitted broad-based panels. But then in 3-judge bench in Core 1, I will call it, the Supreme Court said that any kind of panel appointment is permissible. This came to be overruled in the Constitution bench of Core, where the Honorable Supreme Court took the view that this would violate Section 18 read with Section 12.5. Now the bit on reading with Section 12.5 was a point that was debated. There were various arguments that were made. One argument was that it has to be 18 simpliciter. The other argument was 12.5 read with 18. And the third argument was it's perfectly permissible. The second view was accepted. And since there is a 12.5 violation, the same rationale as I gave you earlier will apply. And today, even in the context of a unilateral panel appointment, there will be an ineligibility and a section 14 can be filed. If such a 14 is filed, the mandate will have to be terminated. Now I will come to the power of appointment. Now, this is slightly more, not as much certainty on this. Now, in the context of power of appointment, the issue is this. The arbitrator is appointed by the High Court under Section 11. But today, under a Section 14, mandate is terminated. 14 and 15 provide to substitute an arbitrator. Will the district court be able have the power to say, I'm terminating the mandate and replacing the arbitrator with so and so? Now, the view that's been taken by various high courts, I don't think there is a Supreme Court ruling on this, is that the district court stops at termination, and that for Section 11, you will thereafter have to go and file a Section 11 before the High Court for appointment. With respect, this may not be, well, I understand it's a difficult scenario. The ideal scenario should be for 14 and 15 itself to lie before the High Court, so this issue does not arise. But again, to go back to filing a 21 and is not what is contemplated with the scheme of 14. You don't go back, issue another 21, file a Section 11. That is not the scheme. But 14 is a little uncertain. So when you look at the language of Section 14, 14 says the mandate of an arbitrator shall terminate and he shall be substituted by another arbitrator if. So it says he shall be substituted by an arbitrator, it doesn't say by whom. Thereafter, other parts of 14 use the word court. Again, if you look at 15, 15.2, where the mandate of an arbitrator terminates, a substitute arbitrator shall be appointed according to the rules that were applicable to the appointment of the arbitrator being replaced. It again doesn't say replaced by whom. It doesn't say court. If the words used were court and it was the 2-1E court, there would be no difficulty. Now, because of this, the ambiguity arises. So you now have a scenario where if you're going to imply that the court will have to be the 2-1E court, you will have a scenario where the appointment is by the High Court, the substitution is by the district court. But by and large, courts have taken the view that you need to file a new Section 11. I am not sure that this is theoretically, at least this doesn't appear to be correct with great respect. Then you look at the language in 29A, because in the context of 29A6, which Justice Harishankar was referring to, the language used is that the court can appoint a different arbitrator. That has come to be interpreted, and the Supreme Court has taken the view in the chief engineer, I think DSC is the judgment, recent judgment. The Supreme Court has taken the view that the substitution can be by the district court. Now, maybe this is a recognition of the fact that whoever may be the appointer, even if it is the High Court, the district court has the power to substitute, and perhaps this logic can be extended even to 14 and 15. So this is the next issue. Then the other issues that arise, yes. Another 2-3 minutes, I will conclude. Yes, I will. All right, then let me just one point I will say, and then I will stop there. What if a Section 29A application is filed after the mandate expires? Does the court have the power to thereafter extend the mandate under 29A? The answer is yes, based on the judgment in Rohan Builders. Thank you.
So I request Justice Muralidhar to make his address before we take any questions.
Good afternoon, everyone. I'm grateful to the Gujarat High Court, the Academy, and all the learned judges for facilitating this whole seminar and inviting all of us to be on this panel. It's been very educative for me, definitely. The kind of issues that have been raised so far. I know that we'll be cutting into your lunch hour, and that's very unfair. Everybody has a right to food. So I'll try and cut short as much as I can. So one one point I wanted to make straight off is the interlinkage between the Arbitration Act and the Commercial Courts Act. So if you go into the Commercial Courts Act and Section 11 in particular, you have to first be clear about your jurisdiction. So whenever somebody approaches you with a Section 9, two things have to be kept in mind. If you're a commercial court, then Section 11. Even if you're not, Section 9 has something to do with the jurisdiction of your court, because the clause, the arbitration clause in the agreement has to be studied very carefully. If there is a line there conferring exclusive jurisdiction on a certain court, you should be extra careful in entertaining that application and be convinced that notwithstanding there is a conferment of jurisdiction by the parties on one court, why you should entertain the Section 9. So in your order itself, where you're passing any order, you must have clarity. At least the person reading your order should know that you've applied your mind to the issue of jurisdiction. Because this is one of the earliest orders in that whole chain of orders in the arbitration. And what you say in the first instance will be of significance, not that it will ultimately be binding on the parties. I'm sure they'll agree. I mean, they'll argue that, no, this was only at the interlocutory stage. But as a court, when your order is reviewed by a superior court, that court should have, should have no doubt that you applied your mind to this issue of jurisdiction. Second is, you have an international arbitration law, the aspect of curial law, which is the court which will supervise the conduct of arbitration proceedings. So very often in international law, you may say the law of the contract is a particular law of a country, but the curial law, that is where the arbitration proceedings will take place and which is the court, therefore, that supervises arbitration proceedings, can be a different court. So this is again, within the domestic context, you don't have the concept of seat. You have a concept of place of arbitration. You have a concept of exclusion of jurisdiction, which is why this jurisdiction aspect becomes very important. Second, and this has to be emphasized again, the whole purpose of the Arbitration Act is expedition of proceedings. Everybody knows that most of our civil courts are enormously burdened, as are our high courts, which is why we came up with the Commercial Courts Act. We created commercial divisions, and subject to what other senior lawyers on the panel would say, it's a struggle because the same judges who are otherwise, in other rosters are by rotation kept in the commercial division. And they are again subject to the same constraints. A judge continues for a few months, then moves on from the commercial division, let's to the bail roster or, to the appeals roster. So we are not therefore able to take full advantage of these commercial divisions because of real shortage of judges. And that, of course, translates to the district judiciary as well. Despite all this, when you come into dealing with matters of this nature, you cannot have your same hat as a civil court. You have to change your cap. I know you're saying, you've already burdened me with so many cases and so many targets and so many special matters. On top of that, you want me to do this. But that's how we all work. We all work in the high courts, we work in the Supreme Court. The statute, the parliament expects you to give this a different kind of a priority. So it's a combination of two statutes, the Commercial Courts Act plus the Arbitration Act, which means that you cannot have the regular dates that you would give for ordinary civil matters. The dates will have to be shorter dates. You will have to have injunctions limited by time. Completion of service, time for reply, everything will have to get shortened. Otherwise, the ultimate mandate will be defeated. The ultimate object of the act gets defeated because as you see in the amended section 9, it is conditional upon the party who comes to you commencing the arbitration proceedings within 90 days. Now, what is this commencement of arbitration proceedings? Nakul and I were having a discussion. As a typical lawyer's response, we say commencement means section 21. As long as I issued a notice, that's enough. I don't have to do anything more. But there is a way of, as a court, nudging the parties to say, no, you will actually complete a section 11 and get an arbitrator appointed. There has to be some time limit. Otherwise, you get an order under section 9, you file a section 11, forget about it. 11 takes some 3 years, 4 years, the whole act is defeated. And that is not the purpose of the act. So how you frame these issues into your order is very important. Next, all those 3 elements that you talk of for Order 39 or the additional elements you talk of for Order 38, Rule 5, they'll have to be spelled out in your order. Invariably, when as appellate courts, we look at these orders, we ask ourselves, has the judge actually taken note of these 3 elements? Prima facie case, balance of convenience, irretrievable hardship. On the prima facie case, you have to dwell on this jurisdiction part, because much of the argument in arbitration matters turns on a jurisdiction, which then becomes a Section 16 issue, which goes to the tribunal. So if at that early stage you do pay a little more attention to the arbitration clause itself, it will help the reviewing court. Where I find most orders are weak are on this balance of convenience issue. Typically in a bank guarantee matter, a party will run to your court to say, he has already invoked the bank guarantee. He has written to the bank, listen, this is the email sent to the bank or the message sent to the bank. And any time now the bank is going to encash and give him the money. It is at that stage you're asked to interfere. You must, as a court, that case law that has come before you, be very, very, very circumspect in granting an injunction of invocation of a bank guarantee. And time and again, the Supreme Court has told us this only, and it has used the word egregious fraud. Fraud of the highest nature. Not fraud because a person simply says it's fraud. It's very easy to write out the whole paragraph of the Supreme Court as part of your pleadings and say, see, I've pleaded. I've actually repeated the language of that paragraph of the Supreme Court. According to me, this is that egregious fraud. That's not enough. So the party will have to make that extra effort in demonstrating to you what is that fraud. Otherwise, this will get misused. This provision will get misused. Please be very cautious. One way you can handle this is this, and which is some innovation that we do. And I'm sure Hari and others have also tried this. Even if the bank guarantee is encashed, keep it in a fixed deposit in your own name. So you have got the hold of the money as a person in whose favor the bank guarantee was given. You've got the money in your hands. The court is saying you keep the money, but keep it preserved. This could be an innovation, right? So that the other party knows that in case that other party succeeds day after tomorrow, sometime down the line, that money is still available. So this is a kind of innovation, even if you're convinced. This is only if you're convinced that there is a fraud. This is a case of fraud. Still, then you could say, I will not completely injunct the invocation of a bank guarantee. I will make sure that the money is made available and is not used by other party. So this is a way of, innovating a relief. So in your order, you please explain why you're doing what you're doing. What we tend to find, and this is another matter for concern, we are unable to write precise short orders. At the end of the day, it's an order of an interlocutory nature, right? If you start writing 50 pages, 60 pages, 70 pages, it becomes very easy. I'm just telling you of sheer experience. It's very easy for the court reviewing your order to say, oh, looks like some complicated matter. Looks like we have to examine this. And then the easy way out, which is what Somerset Maugham is so admired. See, writing a novel is much easier than writing a short story. Because you have to be precise and accurate. So my advice is this, mentally give yourselves word limits. An interim injunction order or a Section 9 order should not exceed 3,500 words. Are you able to do it? Use footnotes. Today we have the facility of, all this Word document, footnoting. You have younger people among your staff who will help you with all of this. Some of your children, grandchildren may help you. What I'm saying is, let's say you're citing 4 judgments. You don't have to set out long passages of that judgment. When High Court reads your order and you start quoting judgment after judgment after judgment, without actually summarizing what the judgment is about, the High Court says, oh, this is the easy way out. You give me a 20, 30-page order, a 40-page order, 20 pages are full of quotation of judgments. I am drawing a conclusion that you're just citing it for the sake of citing it. So please use footnotes. Please try and see how you can summarize a judgment in 2 or 3 lines. That way, your order becomes crisp and it communicates. See, most failings which I find, and this is because of sheer work pressure. I've been judged myself, so I can say it with some degree of experience. It's an easy way out to just quote, petitioner said this, respondent said that, Supreme Court says this, conclusion. So there is no reasoning. We're looking for those reasons, right? The court reviewing your order is looking for reasons. The lawyer or the parties who are reading the order want to know the reasons. They say, oh, it's fine. My lawyer's arguments have been noted. His lawyer's arguments have been noted. Supreme Court judgments have been noted. Why are you concluding what you are concluding? Right? That's right. So don't take that easy way out. People want to know how your mind works, right? And that is the real challenge of being a judge. And you fall into the trap of template orders. Please don't do that. It becomes very predictable. Mr. Soparkar will immediately, when he says, oh, it's this judge, he knows this template. He knows whether there'll be reasons, not reasons. People are watching you. The bar is watching you all the time. You earn the respect of the bar when you actually give reasons for your judgment. The bar is not unhappy if you don't give relief. This is a myth that lawyers will be unhappy if you don't give them relief. It's not true. Lawyers really respect judges who give reasons for their decisions. That's the truth of the matter. So that reasoning, it will come through experience. If you're a young judge, just entered the system, try and see the best practices. There are seniors in your own judiciary. Sometimes when you read their order, it's better than the order of some other person, right? You make a mental note. When you read High Court judgments, you make a mental note, okay, so crisply stated, right? You look at Supreme Court judgments, again, same. We can have the same criticism. At one point in the Supreme Court, I think SEC volumes went to 21 or 22. Because judgments are coming out in, dozens on a daily basis. But same problem. All judgments cited, all arguments noted, one paragraph conclusion. So it doesn't have a precedential value. So try and see which are the best formats of judgments. I would urge you that in section 9, don't write more than 4,000, 5,000 words maximum. If you can write less than that, even better. On the technical issues, one issue that you might be faced with is who can be a party in a section 9, right? So the parties in section 9, and Justice Dhanuka, we had just that exchange, need not be the parties to the main arbitration. This, the Act itself permits. Judgments of the Supreme Court also recognize. Typically in a bank guarantee situation, the direction not to release the monies has to be given to the bank. So the bank necessarily has to be communicated that order. So the bank is not a party to the arbitration proceedings, but becomes willy-nilly a party in the interim, interlocutory stage. So this is something that we are aware of, we are conscious of. So one paragraph where you acknowledge that although the bank is not a party to the arbitral proceedings, in order to effectuate those kind of reliefs that I'm granting, either in the section 17, section 9, so many reliefs, you say, yes, the bank will have to, and put a compliance date. Always make the date for compliance. That way everybody is, before you and not in a long distance. And these have to be very tightly monitored by you, whether it's your reader or your court master or whatever you call them here. Tell them these are arbitration proceedings, so different track. Have a different coding for it. Don't let it get lost in the maze of matters. Last is this, whether you can enforce your orders under 9 and 17. I think this was a question raised by them. Very pointed question raised by some of you. Do I have the powers under 39.2a? Do I have the powers under 39.4? And now I have at least a confirmation from the person to my left, Hari, and from Nakul to the right, that once the statute has been amended to say that all the powers of a court are available to the tribunal, then it's possible for us to say that the tribunal also will exercise those powers under 39(2)(a) and 39(4). So if they come to you saying that, listen, I can't go to the tribunal for this, I have to come to you, you possibly can take a view which can be tested by a challenge to a higher court, saying that no, we will recognize this power of the tribunal to exercise this power under Order 39(2)(a) and Order 39 Rule 4. And now it's time for lunch, hopefully. Thank you all of you for your patient listening.
Any questions? So I may just add on to what Justice Muralidhar had said about this bank guarantees and in stay of invocation of bank guarantees, that there is one judgment of the Supreme Court in Svenska Handelsbanken, in which the Supreme Court has taken a view that because the three principles that apply are either egregious fraud, special equities, or irreparable loss, in a case where the invocation is otherwise the bank guarantee is unconditional. There, in Svenska Handelsbanken, the Supreme Court has gone further to say the element of fraud must also permeate the other two considerations.
And the underlying contract.
Yes, yes. So the scope is very limited.
Yeah. The other principle that's been highlighted is the bank guarantee is itself a contract.
Yes.
So it's not the underlying contract alone that's fraudulent, but even the bank guarantee has been issued by way of fraud. So this is an additional layering of that, and the court keeps on reminding us that bank guarantee being an independent contract has to be honored.
From anyone? Yes, yes, sir.
This is with respect to the court. Section 17 speaks about the interim order which is to be passed by the tribunal. And section 17(2) speaks about the fact that the order which is going to be passed by the tribunal is going to be the order passed by it is deemed to be the order passed by the court. Now section 27(5) speaks about the contempt of the order. Maybe somebody who is flouted the order can go to can take help of section 27(5). Section 27(5) speaks about the contempt proceedings, the order of the that can be challenged only before the Honorable High Court. And when it comes to enforcement, when it comes to the non-following the order, maybe the flouting of the order under section 17, read with section 17(2). So my question is, what is going to be the court? Whether we being the district judge, it would lie before me, or when we read section 27(5) would lie before the Honorable High Court. That is the only question.
17(2) doesn't say High Court. Just give them.
In fact, section 17(2) speaks that the order which is going to be passed by the tribunal it is deemed to be the order passed by the court under CPC. So my question is whether I'll have to go under section 17(2) and will take up the case when somebody has flouted the order of the tribunal, or I'll have to refer to section 27(5) because section 27(5) speaks about the contempt, the order which is flouted by the opposite party. So contempt jurisdiction is with the Honorable High Court, whereas I read section 17(2), I being the district judge, I'll have to take up the case. So my question is, under this circumstance, if somebody is coming up with a say that somebody has flouted the order of the tribunal, would it lie before me or would it lie before the Honorable High Court?
17(2) doesn't bring in the court. Just read 17(2), subject to any orders passed in appeal under section 37. Any order issued by the tribunal under this section shall be deemed to be an order of the court for all purposes and shall be enforceable in the same manner as if it were an order of the court. So that 27(5) stage will come in after the tribunal exercises the 17(2) power and still there is disobedience.
Because lawyers are arguing that since...
No. So that's why I'm trying to explain. the tribunal itself will first exhaust 17.2. Because 17.2 is spelling out the consequences of not obeying the order passed under 17.1. So it will act as if it's the court. It will have all the powers of the court, which is what we are talking of 39.2a or 39.4. And the tribunal's orders in pursuance of that, if it still remains not obeyed, then we go to 27. That's how we can harmonize it. Correct.
17.2 gives enforceability to the order of the tribunal.
Correct. Absolutely.
Or probably 39(2)(a) will lie with the court. But if it is contempt, the matter will have to be referred to the High Court.
That's right. If it's contempt.
Correct. So therefore, if you look at 27(5),
yes,
it says it can also be in relation to non-compliance. So where the court comes to a conclusion that it is contemptuous,
correct,
then the matter can be referred to the Honorable High Court for under the Contempt of
But
Courts
that
Act.
only comes then.
Correct. But otherwise 39(2)(a), the district court will be entitled to exercise the power.
Yeah, but that power itself has been given to the tribunal.
Correct. But on a reference, district court can also do that.
Well, it all depends on again how recalcitrant the party is.
Correct.
There is, my question is on the statutory arbitrations. Today, because of probably SEBI and MSME, those parties who are otherwise by party autonomy not entered into an arbitration agreement themselves are statutorily bound under an arbitration clause. Now, please see, an investor in SEBI who is probably a housewife does not know about anything. There is a SEBI online circular which says that the hearing will take place there's only one or two, maximum 2 hearings which are granted. Second, when there is an MSME who under MSME Act is a buyer and therefore he has to pay. He is one of those mom and pop stores who does not have a legal counsel or a legal department. Under those circumstances, if an award is passed with inadequacy of opportunity A and B not having sufficient evidence because of the very nature of the party who is before a statutory arbitration. My question is therefore whether these statutory arbitration, when they come under section 34, should be looked at from a different point in terms of public policy of India. After the public here is a pan store or a moms and pop or a housewife who is an investor but has been relegated to 34 because of the statutory this thing. So both points.
So the answer is Section 34 applies to these situations irrespective of who the parties are. If there is a breach of principles of natural justice or otherwise the arbitral tribunal has conducted itself contrary to law, that can certainly be a matter which can be taken up under Section 34. But it will not be open to you to say that because I happen to be a widow or ignorant of law, please give me a leeway. You will have to establish prejudice to you on account of act or omission on the part of the tribunal. See, the very issue arose before the Supreme Court from a slightly different angle. Can High Court maintain a writ petition against the award of MSME Council because party did not prefer Section 34 because, as I said earlier, it had to deposit 75% money. So the writ petition was filed. Supreme Court has taken a view writ petition is not maintainable at all. In the later judgment, Supreme Court has doubted correctness of this order. Matter is referred to larger bench in state of Tamil Nadu. Probably Supreme Court is saying it is not correct to say it is not maintainable because writ would always be maintainable but should not be entertained unless gross facts are to be found. Therefore, I do not agree that because statutory arbitration encompasses people from every walk of life, we will apply different standards for looking at Section 34 proceedings.
Section 34 is not elastic enough to change its color depending upon the kinds of arbitration, but court certainly has the power to examine, while examining Section 34, whether or not the basic principles of justice are followed by the arbitral tribunal or not.
So the limitation of 34 is basically based on the party autonomy, that when parties have themselves agreed for other than a civil court, which is an arbitration and therefore a summary proceeding in that sense, you must not now come before a regular court and have a restricted challenge to a award. In that sense, maybe public policy or patent illegality should be given a broader view, because after all, those are the concepts which the courts have brought into.
But a statutory arbitration is in lieu of private arbitration. It is not as if statutory arbitrations are being run on a model other than private arbitration. Even statutory arbitrators will permit parties to file pleadings, raise issues, evidence would be led, order will be given or award will be given. So it is not as if because it is a statutory arbitration, principles of the Arbitration Act are watered down, and therefore because it is not something which is covered by regular rules of arbitration, at the stage of Section 34 we need to give a bigger leeway. I don't think that would be a correct approach. If anyone would like to supplement.
So then, thank you everyone. It's been a wonderful session, and I think we've all been enriched, at least I have, and it's been wonderful. Thank you everyone, and I'm again grateful to all of you for having felt me fit enough to participate in this session. Much love, Chair. Thank you very much, all of you.
Thank you. Before the dignitaries may leave the dais, just maybe request the Honorable Registrar General of Honorable High Court of Gujarat, Shri Sanjay Suthar, to felicite My Lord Justice Vishen first. May I now request Honorable Justice Vishen to felicitate the Honorable Chairperson. May I request Justice Vishen to felicitate Dr. S. Muralidhar. Justice Vishen may felicitate Mr. Diwan, please. May we now request Justice Vishen to felicitate Mr. Suparkar. Lastly, if I may request Justice Vishen to felicitate Mr. Krishna. With this, we come to an end of our first session for today. We shall break for lunch for 1 hour. We'll assemble again here at about 2 o'clock. May I request all the principal district judges, all principal family judges, all senior civil judges and lawyers to head for lunch on the 3rd floor. All additional district judges on the 2nd floor, please. And if I may request the participants to leave on your right. Good afternoon, everyone, and a very warm welcome again. This takes us to the last and final session of this conference. And with that, may we request Shri Ankur Patel, Judge, City Civil Court, Ahmedabad, and Shri M.S. Amlani, Assistant Director, Gujarat State Judicial Academy, to kindly escort the dignitaries, Honorable Mr. Justice Bhargav Karya, Honorable Mr. Justice Ramesh Dhanuka, Honorable Mr. Justice Gautam Patel, Mr. N.L. Raja, and Mr. Unmesh Shukla to the dais, please. Before we commence the last and final session, we have the honor of introducing the esteemed chair and the panelist. We have Honorable Mr. Justice Bhargav Karya as our chairperson for this session, whose academic and professional journey is a distinguished blend of commerce, accountancy, and law. Having first qualified as a chartered accountant in 1990 and then graduated from Gujarat University in law in 1993. He practiced extensively before our High Court in specialized tribunals before being elevated to the bench in 2019. Through his judgments, Justice Karya clarified the procedural lapses such as delay in curing registry defects, which cannot defeat a validly challenged arbitral award, reinforced that arbitral awards are severable, allowing courts to uphold valid portions even while setting aside defective parts, emphasized that objections over arbitral fees do not undermine the jurisdiction or independence of the tribunal, thereby strengthening party autonomy, etc. His rulings have brought greater clarity to questions of jurisdiction and arbitrability in complex commercial disputes, particularly those involving cross-border elements. Justice Karya's judgments have set new standards for impartial appointments in arbitration, especially addressing the widespread issue of unilateral arbitrator appointment by NBFCs. His decisions have provided affected parties new avenues for justice under Article 226 and 227 of the Constitution, where egregious breaches of due process and natural justice have occurred, reinforcing the supervisory role of the High Court in exceptional circumstances. Thank you very much, my lords, for being part of the panel, and we welcome you.
Our first panelist is Justice Ramesh Dhanuka, former Chief Justice, the Bombay High Court. Rising from an outstanding academic foundation at the University of Mumbai, Justice Dhanuka has had a remarkable career spanning advocacy, judicial service, and thoughtful scholarship in commercial law and dispute resolution. Justice Dhanuka's professional journey, commencing in the year 1985, is marked by decades of versatile practice before the Bombay High Court, enriching municipal, constitutional, and company law, as well as arbitration. Justice Dhanuka was elevated to the bench in 2012 with confirmation as a permanent judge in 2013. His tenure on the bench yielded landmark judgments that expanded access to justice, upheld party equality, and clarified the procedural flexibilities inherent in arbitration. Beyond the bench, Justice Dhanuka has educated and inspired legal community through scholarly articles, lectures, and published guides, distilling the evolving standards and principles of arbitration law for both bar and bench. His advocacy for procedural fairness, natural justice, and minimalistic judicial interference in arbitral awards continues to resonate, reaffirming the ideals of transparency, efficiency, and inclusivity with Indian arbitration system. Justice Dhanuka brings both wisdom and a reformative spirit, and his insights will deeply enrich the dialogue on strengthening mechanism. Thank you, Your Lordships.
Our next panelist is none other than Justice Gautam Patel, former Judge, High Court of Bombay. Justice Patel's journey from academic prodigy to judicial stalwarts has been a remarkable for intellectual depth as for his celebrated wit and linguistic flair. After completing his academic timeline in India, Justice Patel's intellectual pursuits then took him to California, where he received specialized training in environmental law at the Pacific Energy and Resource Center. He undertook further coursework at UC Berkeley School of Law, a testament to his commitment to breadth and excellence in legal learning. Elevated to the bench in June 2013, Justice Patel served at the Bombay High Court until his retirement in April 24, leaving an inedible mark on arbitration law. As a judge, he authored landmark judgments urging arbitral awards to reflect both contractual fidelity and evidentiary rigor. These judgments expanded commercial arbitrability and affirmed the enforceability of arbitration agreement. His judgments are alive with insight and precision and a command of language. Justice Patel was widely celebrated for bringing wit, humor, and literal flourish to his court. Thank you, sir, for your participation today.
Our next panelist is Senior Advocate Mr. N.L. Raja, who is one of the most respected voices in Indian arbitration and commercial law. Having over nearly 4 decades of practice at the Madras High Court, Sir was designated as Senior Advocate in 2016 with wide exposure in arbitration, constitutional law, consumer protection, and energy. He is the founding director of the Nani Palkiwala Arbitration Center, the first institution of its kind to be recognized by Madras High Court for administrative assistance in arbitration and has been a driving force behind its expansion to New Delhi. Sir has also played a pivotal role in law reform. He has served on the Supreme Court constituted committees and has been a member and consulate of the Law Commission of India on several occasions. Notably, Sir has contributed to 246th report, which laid the foundation for the landmark 2015 and 19 amendments to the Arbitration Act. He further assisted the Commission's work on the Commercial Courts Act and was actively involved in the Justice Sri Krishna Committee on Institutional Arbitration, contributions that have significantly shaped the statutory and institutional framework of arbitration in India. Thank you, sir, for your presence to the panel. We now move on to Senior Advocate Unmesh Shukla. Any advocate either practicing or aspiring to practice on the original side looks up to Sir. With an academic bent of mind, Sir passed his bachelor's and master's of law with flying colors. Owing to an illustrious career in the areas of civil and commercial laws, Sir was conferred with senior designation in the year 2022. Sir is known for his methodical, research-oriented, and strategic approach towards matters, and is one of the most sought-after counsels in the matters pertaining to arbitration. Sir continues to mentor the next generation of lawyers and professionals. Sir has authored the prestigious 7th edition of the book Mullah, The Key to Indian Practice. When it comes to trial advocacy, his keen command and passion for subjects like arbitration makes him an imperative and indispensable contributor to the panel. Thank you, sir, for being a panelist.
With this, may we request the Honorable Chairperson to take the proceeding forward, please.
Very good afternoon to all. First of all, I thank Honorable the Chief Justice for providing this great opportunity to all of us, and more particularly to me, to chair this session on the vital subjects which touches to our day-to-day function of at the back end of this 2 days brainstorming conference on arbitration law. Making of an award, termination of arbitral proceedings. Most important topic is enforcement of award, which comes regularly before us. And whether it is domestic or international law, jurisdiction of law, and a law of applicability of law of limitations. In the arbitration, these topics will be deliberated in this session. In last 3 sessions, we have been benefited by the experts on the topic of arbitration law, covering from the essence of arbitration, role of courts under section 8, 34, 37, concepts of arbitration law regarding party autonomy, understanding legal framework under section 7, 10, 11, 19 and 20, challenging the arbitrator's role under section 12 and 13, jurisdiction under section 16, equitable principles enumerated in section 18. And today, first session, we learned a lot with regard to the interim measures under section 9 and 17 by the courts and the arbitral tribunal respectively, anti-suits injunction, anti-suits injunctions, statutory arbitration, termination of mandates, substitute arbitrators under section 14, 15 and 29A. Having traveled through the scope of the Arbitration Act since last 1.5 days almost, and the conduct of the arbitration proceedings, we have now reached at the stage of making an award. Cost to be awarded. Termination of arbitral proceedings as provided under section 31, 31A and 32 of the Act respectively. The most important stage after making an award is enforcement of the award under as per section 36 of the Act. For an award enforcement is provided in part 2 of the Act. The jurisdiction of the courts and limitation in Arbitration Act as provided in section 42 and 43 of the Act are also important. With the experts on the subjects, Chief Justice Dhanuka, Justice Patel, Mr. Raja and Mr. Shukla, having vast experience on arbitration act and practice, we are sure that we will understand and decipher the intricacies and nuances of making an award and enforcement of the awards, without which the entire arbitration proceedings under the Act would be a futile exercise. We were to take up the topic of section 31 of making an award and 31A first in point of time. But as Ms. Justice Patel might have to leave early, we have had a slight deviation and we'll take up the enforcement of the award. Thank you. For the under section 36 over, and thereafter we'll go to making of an award. So chapter 8 of the Act, which provides for finality and enforcement of arbitral award, with amendment to section 36 from the 23rd October 2015, regime of automatic stay, which was prevalent till then, is removed, so as to enforce the arbitral award as a decree, unless stay from the court is obtained by the losing party, that is under section 34. The significant aspect of section 3 of section 36, which empowers the court during the enforcement of the arbitral award to impose conditions considering the facts of the case, often directing the security deposit so as to balance equities and discourage frivolous challenges. That is, of course, discretion of the court. First proviso to section 36(3) has reinforced the approach while considering the stay of an arbitral award for payment of money by the court to have due regard to the principles governing the stay of money decree under the Code of Civil Procedure, so as to harmonize the arbitral enforcement with established principles of civil law to streamline the process. The 2021 Amendment Act, which has introduced the retrospective amendment with effect from 23rd October 2015, has brought a significant shift by inserting second proviso to section 36(3), allowing the courts to grant an unconditional stay of an award if the underlying arbitration agreement or contract, which is the basis of the award or making of an award, was prima facie induced, effected by fraud or corruption, and it also requires introspection as to whether such amendment would delay the enforcement, as making allegation of fraud by the parties is very easy to stall the execution. The scope and the effect of section 36 for enforcement of award is key to success of arbitral proceedings. Merely obtaining an arbitral award would not be sufficient unless the execution of such award is also ensured by the process. This aspect is very significant, as a successful party would insist for execution of the award, and in parallel proceedings, unsuccessful party would challenge the award. Ideally, both the execution proceedings and challenge of the award should be conducted by the same court so as to avoid multiple litigations and increase the cost and delay, and thereby diluting the efficiency gains that arbitration was supposed to achieve. scope of judicial discretion under section 36 is a gray area which should normally be governed by the minimal judicial intervention in practice, as there is overlapping proceedings of challenge and execution of award. That has led to various probable issues which may be flagged, which I may summarize in a short manner so that the experts can focus on that, which this also includes the questions which have been sent by you. In the light of the definition of court under section 2E, whether a civil or commercial court can exercise jurisdiction under section 36 of the Act in case an award passed in an international commercial arbitration. Answer is obvious, but this is a question raised. And it's another question which is part of this is whether reference to Code of Civil Procedure and the court in 36(1) of the Act implies that a civil or commercial court can exercise jurisdiction under section 36 of the Act, even in case an award passed in international commercial arbitration. Another issue which is flagged is how and when can an arbitral award be enforced as a decree under section 36, which is the main contents of this section. What is the extent of discretion available to civil or commercial courts ordering deposit of award amount while staying in award in an application under section 36(2) of the Arbitration Act, while staying the operation of an award, section 36(3) of the Act, whether court can permit the award debtor to furnish solvent securities by way of mortgage over unencumbered involved property instead of insisting upon bank guarantee. These are the basic questions which are raised. Now, in regard to section 36(3) of the Act, whether the court should determine the contours of fraud as referred to in proviso to section 36(2)(3), and does the reference to fraud followed by word corruption only mean fraud perpetrated by the tribunal, or can fraud be widely construed so as to include suppression of material fact, misstatement, etc. by a party? Parliament removed the automatic stay on awards in 2015. Has this reform truly reduced the delay in enforcement, or has it merely shifted the battleground to stay applications under section 36(2)? If a section 34 petition is pending but no stay is granted, should executing court adopt a cautious approach or enforce the award like any civil decree without hesitation? And should government entities facing large arbitral awards get a more lenient standard for stay and security, or should the law treat them no differently than private parties? And lastly, does the treatment of arbitral award as civil decrees under section 36 strengthen the arbitration's credibility, or does it expose arbitration to very procedural delays it was meant to avoid? I throw this house open to Justice Patel, and thereafter it may be followed by Mr. Shukla on these issues which are flagged in relation to the execution of decree. Patel, Justice Patel.
Thank you, Justice Karya. Thank you, Chief Justice, for having me here. It's a privilege. I want to, before I just dive into this and probably drown, I do want to say this, that many of you have probably been judges for far longer than I was, and you have probably got a wider range of experience. I'm here, I think, by accident rather than design. And given that, I don't want to be seen to be lecturing. I'd rather put some thoughts and suggestions before you for you to consider, because these are problems that all judges at every level come across sooner or later. Before we get to 36, which I think is a critical part of the Arbitration Act, there's a couple of comments by way of a preface. You know, there is a very strange kind of controversy and a dichotomy or a divergence sought to be drawn between commercial and non-commercial matters. This is a false distinction. We have to understand that when we're dealing with arbitrations, we're dealing with commercial matters. And commercial matters, though they may be smaller in terms of the number of filings, they have a disproportionate influence outside courts on the economy. They are the engine that drives the economy. They affect how people go about their daily lives. It's a mistake to think about commercial arbitrations as being between these huge moneyed supergiants. Justice Dhanuka will attest to this, that we've got arbitrations that have to be sorted out between housing societies and builders. We've got arbitrations that have to be sorted out between small traders, and these may even be statutory arbitrations. So arbitrations are not, and commercial matters are not to be seen as inconsequential. The other thing that our commercial matters do is that you will find, and particularly in 36 and in 34, they take a disproportionate amount of the judge's time. And that's where we as judges come into the picture. We have to save that time because there is that overarching concern under the Arbitration Act that it has to be a speedy remedy, not just to the award, but to enforcement, to gain finality. And why do we say this? Because there is a recognition in the Arbitration Act and in the Commercial Courts Act that a speedy disposal of commercial disputes is a societal need. It is what the country requires. These are not to be seen as luxuries. That's the point that I want to make. In fact, the faster you dispose of commercial matters, the more time you will have for the non-commercial matters. And that's an important consideration to bear in mind. When we approach 36, let's remember a couple of things. One, 36 was completely substituted by the 2015 amendment. At that time, before that time, there was this concept of an automatic stay. And if you look at 36 carefully, you will see, again, I'm sure Justice Dhanuka will bear me out on this, that it has a sort of cascading or a waterfall structure to it. Just follow this with me and we'll see the logic to it. The first thing that happens is in 36(1). What this says, and this is really sets the frame for the whole of 36, that once there is an award, it is going straight to enforcement in our hands as executing courts. You do not need to make it a rule of the court. You do not need to make it a decree of the court. And Order 21, Rule 11 can be filed directly on the award and your darkhast proceedings can begin on the award itself, subject to this, that the time for making the application under 34 to set aside the award has expired. So once there is a clear run, it operates exactly as a decree of a civil court would and should be enforced this way. Now, I don't know how many of you remember that legendary line from the earlier edition of Mullah, which LexisNexis has deleted for some reason, which says that the problems of a litigant in India begin when he has obtained a decree.
The Privy Council observation.
Now, this is not something that we want to encourage. This is not something that we want to foster. It is actually on an international level putting India in a very bad light. There is no point in discussing foreign direct investment into this country if you are not going to deliver enforcement of our decrees and our awards in a fast and efficient manner. In arbitration, the fastest manner to do this is a 5-letter word, money. Bring the money in is the simplest way to do this, and I'll show you how this happens within 36 itself. So 36(1) begins by telling us, don't waste your time trying to figure out whether this should now be made a decree of the court. It is enforceable as if it is your decree. All right? But look at 2. When the application under 34 has been filed, this is what is going to most often happen. The filing of the application does not make the award unenforceable. That's part 1 of 36(2). Part 2 is unless the court grants a stay in accordance with subsection 3. So 36(2) splits into 2 streams. The first is that it is not an automatic stay, and my suggestion, as I said, I'm only making suggestions, is that an arbitration court dealing with enforcement must be completely unafraid to refuse the stay except on terms. Now 3, which ties to the second part of 2, saying that when there is an application for stay, the court may grant stay on such conditions as it deems fit, and then the first proviso tells us that we have to have due regard to the provisions of the CPC for grant of a stay against a money decree. What does the CPC say in Order 41 in a situation like that? Which is secure the amount. Now, if you have this overarching objective of a quick enforcement, how best to assure this? And let us stop here at 36(3) for a moment before we come to the 2 provisos and the explanation. Oh, sorry, the second proviso and the explanation. The easiest way to do this is not to say we'll hear the 34 and the 36 together, because that is meaningless. That's really meaningless. The 36 stay application has to be heard first. And the first question that I would put to anybody seeking a stay is, if there's a award against you, how many millions of dollars is it? They would say some fantastic number. So it's already deposited. Or give me a bank guarantee. The simple reason for this is actually enforcement is 36(1). Let me explain that. If the challenge under 34 succeeds, the money that is secured or deposited will go back. There's no problem. But if the challenge to the award fails, the award holder then has the security or the deposited money to proceed against immediately, and it closes the enforcement proceeding fully. You then don't have to move in attachment. You don't have to move for other reliefs under Order 21 with all their attendant complications. In fact, my recommendation is please see 36 as the fast lane through CPC Order 21. This is the super fast highway through Order 21 if it is being made applicable. It's not a shortcut, but it's a statutorily provided quick mechanism for enforcement. The logic to the second proviso. On a prima facie case of fraud or corruption. Now, this is a gray area. I don't know where this has been actually fully tested and resulted in a decision of a higher court, because fraud requires material particulars and would require evidence. You would have to have, my view, an overwhelming case of fraud or something that says this can only be the result of either fraud or corruption, and there is no other explanation to this. This is an exceptional case. It should not become the standard. It is therefore an exception to the norm, which is don't grant stay without security. Don't ever grant stay without security. Now, should you take security other than money or bank guarantee? My recommendation would be no. Because when you start getting security in the form of property, there are always inevitably complications in the realization of that security somewhere down the road. Money has no color. Money in the registry is money in the bank, and it will earn its interest there, which is really where it should be. Now, for the explanation, is not something that should detain us very much longer. The reason for the delay, going back to some of the questions that came from you and which Justice Karya read, is when we confuse the 34, which is a challenge on restricted grounds, which I believe you saw yesterday, with an application for stay. Now, the application for stay can't be just a stay for the sake of it. The application for stay would have to make out the usual requirements of a case for injunctive relief and for a stay. There would have to be a very strong prima facie case. There would have to be a case of a balance of convenience that the award holder will suffer no great harm if the stay is granted. And there has to be the irreparable harm situation that has to be shown. I would say that those are the factors that have to come into play when you are addressing a stay application. The general rule, in my view, should be no stay, no unconditional stay, stay only on security, and partial security only in the most exceptional case. Have the amendments helped? Have they smoothened things out? Debatable. But let's be clear about one other aspect. The success or failure of any statutory provision, amended or unamended, depends not only on what the statute says, but on how we as judges apply it. Litigants and lawyers will endeavor and will do their best to drag things out and to spin it their way. And ultimately, it is up to us to bear in mind the fundamental underpinnings of the Arbitration Act and the Commercial Courts Act, and to understand why we are set here to address this problem of enforcement in this fast track mode. Once we have that in mind, I think the rest of 36 more or less falls into play. If there are any questions, I'll be happy to take them.
Thank you, Justice Patel. Now I request Mr. Shukla to throw light on this topic.
Let me start by thanking the Honorable Chief Justice for allowing me to be here as a co-panelist with such eminent persons. I entirely endorse Justice Patel's views. The Privy Council said in one judgment that the trouble starts for the Indian litigant after the decree is obtained. And we want that dictum to be erased. Now, how it can be done? When the award is passed, when the arbitrator has, after considering both sides, allowed the claim, and when the enforcement comes, the stay has to be granted on deposit of the money. Only. Bank guarantee is also a promise. Immovable property is still worth security because the investigation of title, so far as that immovable property is concerned, may throw many problems. There may be hidden claimants. There may be some hidden mortgages which are not registered. So accepting any security other than cash has their hazards. And the losing party has to respect the party autonomy for which it has clamored. Before they lost, both parties were saying that we want party autonomy. Now, simply because you have lost, that doesn't mean now the scale should be different. So with respect, when 34 application is filed, along with the application, section 36 application is filed for the stay. What is my experience as a lawyer? Because I still continuously engage in the commercial courts, and I'm happy to say that we have wonderful officers all over Gujarat. I have gone to many places and they have shown great talent. The only thing is that they still feel that there is some hesitation in directing the losing party to deposit the entire decretal amount. That hesitation with respect needs to go. Let the money come. Not only that, if I see the proviso to 36(3), on such terms and conditions, the stay may be granted. And that term and condition could also be that the winning party can take away a part of the proceeds at this stage. So 100% may be deposited, 50% may be permitted to be withdrawn, 25% may be permitted to be the discretion is entirely with the courts. But let the winning party see the color of money. The arbitration comes at a great cost. It is a very expensive remedy. The fees of the arbitrators, the fees of the counsels, the administrative cost. After spending all this money and on a reasonably fast track basis, the arbitration still we have almost the statistical data is that within 2 to 2.5 years, the arbitrations get over. But then thereafter, if we come into the system and if we have to sit in the local train, it's not helping anybody. So with respect, let 36 stay application be decided with a clear direction to deposit, with some money to go to the winning party, and then 34 can be heard at length.
May I just make a suggestion just on this? You know, awards will have typically several portions. Under claim number 1, so much is awarded. Under claim number 2, so much is awarded. Claim number 3, so much is awarded. And there is an aggregate amount. You're not looking at one big lump sum usually. You're looking at various components. The challenge may not be to all of these components. But our suggestion is ask for a deposit of the entire amount, and at least that which is undisputed, allow the successful party to take away. That's half your enforcement job done right there, right then. That was the suggestion that's being made.
Indeed. In fact, in the construction disputes, we have seen that the first claim is invariably the unpaid bills. When the construction contract runs into a dispute, last few running bills remain unpaid. So the first claim is only for the unpaid bills. Now on that, there is practically no chance of a dispute and no scope for a challenge. Why that money be kept pending? And the other thing which I have noticed is that when 36 application is examined, it is not necessary to see prima facie whether this award is vulnerable within the scope of section 34. That is not the mandate of 36. Only if it is fraud or corruption, only in that case, the court may grant the stay unconditionally. Otherwise, the stay has to follow the principles of Order 141, Rule 5. And that is where I believe that our courts can make amends and start granting the stay on these conditions. The other thing what I have noticed is that when 34 is being argued, the advocate who wants, of course, who is not interested in paying the money, would say that let both the applications be clubbed. We will argue 34 also, we will argue 36 also, and they would try to say that effectively the arguments for both are the same. But with respect, this is not correct. For the stay of the award and for the main challenge to the award, the arguments can never be the same. For granting stay, with respect, it is not necessary for the courts to examine whether the award is prima facie vulnerable or not. This is what I think will significantly change. If we want the arbitration-friendly regime, the courts will have to come forward to assist the arbitral process in this fashion. This is my view.
Absolutely right, Unmesh bhai. We as a judicial officers, it's our duty to see that arbitration for which we have deliberated for all these last 3 sessions, it is the process of initiation and proceedings of arbitration and challenge to it. But at the same time, if the arbitral award is passed, and if it is not executed or enforced and the fruit of that award is not received by the successful party, then entire proceedings would be of futile exercise, as is my view. Mr. Justice Dhanuka can add if you want to say on this particular aspect as to what should be the approach of the judicial officer, because where the court comes into picture for execution of an award for the purpose of ultimately getting the closure of the arbitration, because this is a closure stage where the arbitration proceedings comes to an end on execution of the award, subject to, of course, challenge in 34. So what as suggested by Justice Patel and Mr. Shukla is to the effect that let the money be deposited with the money decree or other aspects when can be put by way of a security or any other mode which is permissible under Order 21 for execution of a decree.
I am sorry, I partly differ with the views expressed by my co-speakers. For this reason that the words used under section 36 is that it is discretionary power of court to grant stay or not. While hearing that application for stay, this was required to be done because prior to 2004, prior to 2015, there used to be automatic stay because of the judgment of National Aluminium Company. And once you file your petition under section 34 within the time prescribed, till that petition is disposed of, there would be automatic stay. As a result of that, there was a lot of hue and cry that people will not even remove office objection for 6 months. Until petition comes on board after 6 months, 1 year or 2 years, award stands stayed automatically. Supreme Court has taken this view. I had taken the view for the first time in Bombay High Court that this is a discretionary power. This is not, you can't blindly call upon the respondent to deposit the amount. Prima facie, you have to take a view that award is vulnerable or not. Because there may be a situation where it is an ex parte award or principles of natural justice is violated, or it is totally, it shows a patent illegality. There is inherent lack of jurisdiction. If these are the situations come across by you, then simplicity, you can't ask the respondent to deposit. Otherwise, there will be injustice. Of course, you may have to hear the parties on merit partly. It may be a situation where part of the amount is admitted. One of the example given by my brother. Then you, to that extent, you ask him to deposit because there is no question of challenge. You may also have to see that whether entire part of award is challenged or only part of award is challenged. If part of award is challenged, to the extent unchallenged part is concerned, you can straightway ask for deposit. But there are also judgments that deposit may not mean the money in terms of money. You can even ask for deposit of title deeds of the property.
With all due respect, sir, this validity of award, whether it is against public policy or it is a patent illegality, is not the domain of 36. 36, we are at the stage of 36 execution. As per my understanding, execution is as provided under the CPC. CPC Order 21 applies. But instead of rigors of 21, which is said to be like filing an execution petition, as it is generally said, is filing a new suit. It's not there in the Arbitration Act. It's a fast-track execution. And therefore, the stay is provided. Now, with the amendment of Section 2 and 3, which is brought on statute from amendment in 2015, Patel said and Mr. Shukla said
is not about like what they said, that you have to secure the interest of the party who is the award holder. So they say that the misnomer is that what happens that section 36 is filed and 34 is filed. It does not matter which application is filed when prior and point of time. But once 36 is there, mostly like it happens in the commercial court, and Mr. Shukla is very well experienced about it, that they say that here my 34 along with 36, because if you are not hearing 34 and starting with the execution, my 34 right would be frustrated. This is what the argument generally lawyers make. So obviously, as a judicial officer, you think that, see, I have to look to the validity of the award in section 34 And then if 36, I am executing it, and if his right to challenge the award is frustrated, so I should, you get that instinct to connect and then see that, okay, the main focus is on 34 because if award can be set aside, there is the question of execution. So then you tend to connect both of them. But then that is the first step.
Correct.
That takes you for a ride.
And therefore,
Because as soon as you connect, they will come, and this is what has happened in my court. They came in 227 because the order was passed to connect both, decide them. So 1 day, 2 day, they will not be arguing. After that, 36, you have to decide. It was disconnected or something, and they started making arguments. So what Justice Gautam Patel and what Mr. Unmesh Shukla are trying to impress, what I suppose is that you secure the interest of the party who has got the award. Let the amount under award be deposited. Let be in the court. Let the amount be in the court. And the other party who is challenging the award under Section 34, at least there would be a sword hanging on his head. That if you want the award to be set aside, then you'd argue Section 34, get it decided. Because otherwise, what happens that it becomes a trick. For 5 years, you will not argue, take adjournment some way or the other. So what I suppose they said that, and if the portion of the award both agree that all right, out of the 100% deposit, 50% can be released. Release it.
this is what first proviso to section 36(3) provides which I may read, provided that the court shall, considering the application of grant of stay in the case of an arbitrary award for payment of money, have due regard to the provision of grant of stay of money decree under the provision of Code of Civil Procedure, so and so. So that is an duty cast upon the court to see that it is a money decree. While granting a stay under 36, you have to follow what is provided in CPC. As in money decree, the court always insists for payment of the amount.
CPC is not easy.
Easy.
Not is not stay of a money decree.
Correct.
So that is why it said
It has to be deposited. It has to be see that whatever is provided there.
CPC you cannot easily
ask for the payment of the money.
Say no to execute the money decree.
So while granting stay under 36, first thing is that first application of stay is required to be heard, and whenever money decree, let the money be deposited as rightly pointed out by the Honorable Chief Justice and the Justice Patel and Mr. Shukla, that money should be secured for the purpose of the award holder, and that can be deposited in a fixed deposit carrying interest in a nationalized bank, and the money after if the subject to outcome of the 34 application if it is pending. I think that resolves the issue on this aspect. Now, another question which is referred to from the Zoom is, can the assets of director be attached in execution? Discretion, what is the extent of discretion available to the commercial court in ordering deposit of award amount while staying an award in an application under Section 36? Mr. Patel, if you can.
There is restriction on your discretion.
There is no discretion.
There is no, there is discretion.
Yes.
There is a 100% discretion. There is no restriction on the discretion.
Yes.
The same thing that can be done by a civil court, it can do. What was the previous question? I'm sorry, I didn't.
Yes. Can the assets of a director be attached in execution of arbitration award? Just against company, to what extent lifting of corporate can be applied to? The answer is straight no.
No.
Straight no.
The doctrine of corporate, lifting of corporate
can't be in 36.
It can't be done like this.
Yes. Yes, please.
Section 34 and 36, I mean, at least to my mind, and in my seniors chamber, we were told that every provision in a statute is a storyteller. I mean, it is telling you a story, and you need to listen to what the narrative it has to say. And the interesting part of this narrative is that every time you come with a different set of facts, it will tell you a different narrative. So we need to listen to what that narrative is and place it in the context and fit it into the facts of the present case. Now, the problem is, at least to my mind, this section 36(3) has no place in enforcement. It is actually must be in 34. When you file an application to set aside an award, you take out an application for stay. When you take out an application for stay, this is the norm that the court must apply. Because what happens is the enforcement execution petition can be filed in a different court from the court where the section 34 application is filed. Because today, after the judgment in Sundaram Finance, you can file an execution petition in any part of India. But you can file a section 34, and section 34 application is bound by the provisions of section 42. So you can only file it in that court. So the section 34 application is filed in one place, section 36 application is filed in another place. I don't think there is a practice of taking out a stay both in a section 34 and in a section 36. So you take out an application under section 34 and the principle set out in section 36(3) will be applied to that application. And it will grant a stay or not. The job of an enforcement court therefore then becomes much easier. What has it got to do? It has only got to follow whatever has been passed under the 34 Act. Once a stay has been granted under 34, or the court says that deposit this money or provide for a bank guarantee, the enforcement court job is very simple. It only has to follow that. Now, if there is an EP filed and you don't have an interim order, the best that the EP court can do is to provide you some time to move the section 34 court and get some stay order or some conditional stay order. Beyond that, it is no.
There the catch lies. Because moment you grant the time, the matter will never be heard in the 36.
That is an operational problem. It's
so
not
we are concerned with ultimately to achieve the object of the arbitration award, which is in favor of the award holder, so as to see that he sees the fruit of the award first. Then only the object of this arbitration act or success of the arbitration act would be achieved. Why 36(2) is therefore, in that light, what 36(3) provides, we have to see what 36(2) provides. Yeah. Now, 36(2) provides there is no stay of the proceedings moment there is a 34. Let us read that. Only before filing of 34 is not a granting of stay. Then the power is given to the execution court to grant the stay, irrespective of what happens in 34. Whether 34, there may be different things. 34 may stay, application stay, in 34 may say, stay the execution proceedings.
See, we had these problems, multiple problems cropping. Because there is 2, there is a 3, which is consequential.
If there is an order upon filing of an application under subsection 2 for stay of the operation of the arbitral award, the court may. Subcourt may, here court is executing court.
Yes.
Subject to such conditions as it may deem fit. So it has to apply its discretion. Correct. Grant stay of the operation of such award for reasons to be recorded in writing. So, but, okay. So, what would be the test?
Yes.
For granting this stay by the executing
court?
That is the question which...
the parameters at which you would consider whether a stay is to be granted or not. Again, as I said, they'd have to make out a prima facie case. So therefore, I don't think I'm at odds with Justice Dhanuka at all. I'm not saying that it has to be granted just because it's been made. There has to be a case made out for stay, showing reasons why the award is vulnerable and therefore a stay ought to be granted. That has to be a compelling case, otherwise it can't be done. To that extent, I agree.
Yes.
We may have some disagreement between us on what should be the conditions of the stay, but that will vary from court, case to case. And there isn't a one size fits all. Incidentally, I must tell you, there's a very interesting strategy that's now being adopted, which is not to file the 36, because you can delay execution much longer than risk the 36 and getting an order of deposit. So don't file the 36. Let them go under a Darkhas proceeding. We'll take every conceivable objection under Order 21 and we will block off, because assets may be scattered between different jurisdictions also. Whereas when you make a deposit order, all of it comes and funnels into your jurisdiction in the enforcement court. So many people say that if you want to defeat enforcement of an award, don't file a 36.
Don't file 34.
Don't file the 34, but don't file the 36. Let them try and execute, we'll see.
Actually, Justice Patel is quite right in the practice that is being followed.
This is the practice.
We have a problem with that. So how the Madras High Court has tried to resolve it is because it's a chartered High Court, it had that facility. I don't think the Gujarat High Court can do that. What it now does is all the execution petitions are filed before the are filed and posted along with the Section 34. Because then this thing can't be done.
Then this can't be done.
Then this thing.
But elsewhere this is being done.
That is what I suggested, that both 34 and 36 should be filed together but to be heard by the same court.
No, he's saying 34 and order 21.
That is order
21.
Because sometimes if the assets are outside the jurisdiction, there's no point in filing it here.
Yeah.
We will file it elsewhere.
Yes.
But where the assets are here and you filed an execution petition and one party has filed a setting aside petition, the other party has filed an execution petition, Madras High Court says now post both together.
Both together. That is an ideal way. And here the stay application first.
Mr. Shukla doesn't agree.
No, I have a minor disagreement with Justice Dhanuka, and with lot of trepidation I am saying it.
I think he's quite soft, don't worry.
Except for fraud and corruption, that second proviso, I believe that stay has to be granted only on deposit of money. The moment you open the window that we will examine whether this award is suffering from patent illegality, that window will mean that effectively 34 would be argued while stay is granted.
So in any case, we have to read second proviso into the main provision of subsection 3, which gives discretion to the executing court to grant stay.
Yes, madam.
Upon filing of section 34 application and a stay application in section 34. Because the grounds of challenge and the level of scrutiny in section 34 and for stay application in section 34.
High Court are different. High Court can
Stay application in section 38 cannot be same.
It cannot be same.
But there is also an operational problem once again with regard to application of section 36(3), the proviso there, which was introduced to stop awards from being obtained through corruption and fraud. It says, provided further that where the court is satisfied that the prima facie case is made out that the arbitration agreement or contract which is the basis of the award, or please note this, or the making of the award was induced or effected by fraud or corruption. Right. So I am contending in a section 34 that the making of the award was induced by fraud or corruption. But then under section 34, I am ring-fenced by the fact that I can only 34(2)(a), an arbitral award may be set aside by the court only if the party making the application established on the basis of the record of the arbitral tribunal. Now, where will there be any record of the arbitral tribunal about any fraud or corruption in the making of the award? For that, I have to lead evidence. But then section 34 is
Mr. Rajan, this is an area that nobody's explored. I can't wrap my head around how this is ever going to work.
Exactly. I also
by making
an arbitrator saying, yes, here's an award which I vitiated by fraud.
Yes.
It's not going to happen.
Answer this by reading this proviso again, which says a prima facie case.
Well, that is
so for a prima facie case, you never need a record. This is what
that far only we can go.
Tough.
But for a prima facie case,
for a prima facie case, the party seeking stay has to make out the case on the face of the record. And you don't need to divulge into the record.
Yes, you're right.
So all records, whatever the party wants to place it, can place it along with the application for stay.
I am saying that yes, that is the normal procedure, but something new has been introduced. The making of the award was induced by effect of fraud or corruption, and you are stuck with the record before the arbitral tribunal.
No, Mr. Raja, let's take your best case scenario that you come across a nugget of information that shows that the arbitrator was bribed.
Exactly.
That comes on
that comes on record. In the arbitrator is not going to say it that I've been bribed. So you found out that he was bribed.
You have to produce. But 34(4) says that no, you can't.
Then you don't have to
saying, sir. It is not saying that. It is not saying that you have to raise that ground in 34.
It says it will be unconditionally stay.
Unconditionally stay.
That's all it says.
It only says
security.
This is an exception for granting only unconditional stay.
But again, can provision in section 36 expand the provision of section 30?
It is only for the purpose of granting of stay under 36. It is not for execution.
Same provision is there.
36 is only for execution.
That is
Expanded.
to be anyway, in fact, interplaying or overlapping section 34.
Not at all.
They are completely different arenas. These two provisions work in a different area. It's like for execution of a money decree also, I think in CPC there should be the same provision. If the making of the award or making of the decree is induced by fraud
Then
or
stay-
corruption, so it goes to the very root of the
Correct.
validity of the
Correct.
decree.
Yes,
Absolutely correct.
Validity of the award.
Correct.
So that is enough for any court to grant a stay or set it aside.
I mean, they are uniting,
Even ignore it.
they are taking it back to order 21. And
Right.
saying that basically is a decree which is inexecutable.
Correct, correct.
Cannot be executed.
Same principle.
That's a principle.
Because it's a money decree. So for a money decree and the principle of common law that if you are getting a decree or an award is a decree which is induced by fraud or corruption.
Vitiated.
It is vitiated.
But there is one more aspect which has come to our notice, that the second proviso is sought to be expanded by people who don't want to pay. So what happens is that fraud or corruption, now corruption obviously is
Mere allegation is made.
but fraud, now what was argued in one matter was that a party suppressing a document from the tribunal is also a fraud covered under this.
So that is too much.
So that is where I
That we have
wanted
the
the panelists'
that
view.
the discretion lies of the judicial ourselves to say that whether this we can go and travel into that or not. Prima facie, we have to examine, as rightly stated by the Honorable Chief Justice, that this is for granting unconditional stay. So while granting the unconditional stay, these are the safeguards are put that these are the only two circumstances in which you can grant an unconditional stay. So I think enough is on this
We can
topic.
move on.
We can move on to the next topic.
Arya Sahib,
Yes, any questions which are raised?
topic is very important. And those who are really beneficiary, at least we ask the audience what their experience.
Yes, that is a very good suggestion. If anybody wants to share their experience in their current whatever functioning, please can ask the questions at this juncture so that we can have the benefit of Mr. Justice Patel to. That's why we are saying that within 5-10 minutes he has to leave. Yes.
Sir, I deal with some execution petition wherein a person have passed a arbitral award. There is no agreement, no consent of both the parties, no any court's order. A big land was acquired before 50 years and our single heirs have applied to a person who is not advocate, no arbiter, and that person has passed a arbitral award, only issue the notice to the government, and within a 15 days, they pass an award. Just not an award like these. What the award?
So I must interrupt. We are not going to be able to deal with fact-specific cases in.
No. It is over, but now it is not pending, and the award is like a decree of declaratory suit. So whether is this execution petition, whether
There is to some court to decide it.
so whether this award is just not jurisdiction.
Yes, that execution court will decide by granting this petition or granting in such an execution petition. Directly the second proviso would be applicable because it on face of it, it was prima facie, it would appear that it is by fraud. So second proviso unconditional stay is to be granted subject to hearing the other parties. Execution proceedings has to be proceeded in that manner. That is my view, subject to what.
No, the request to the audience is to have questions based on policy rather than fact specific, because it is difficult to opine in such matters. That's what Justice Patel was trying to indicate.
Yes. Any other?
Not as difficult, but improper.
Yes. Any other questions? Yes.
Sir, perusing subsection 2 of section 36.
Yes.
It appears that the power to stay, the execution power has been conferred on court dealing with the application under section 34 of arbitration. Because what it is worded that where an application to set aside an award has been filed under section 34, the filing of such an application shall not by itself render that award unenforceable unless the court grants the order of stay to operation of the said arbitral award. Subsection 3 proviso, the grounds for fraud or corruption is a ground, not for staying the execution of arbitral, but it is a ground for standing an arbitral award. Therefore, though
No.
the provision related to stay of arbitral award has been contained under section 36, but it has to be applied by the court dealing with exception.
No. If you read Justice Patel. No, go ahead. Yes, if you read subsection 2, it clearly states that by filing an application at 34 is not a stay, automatic stay. And therefore, as per subject to subsection 3, the stay will be granted by the execution court pending application under section 34. And how the section 3, subsection 3 of section 36 applies is provided in subjected to proviso that money decree you apply the as suggested to ask them to deposit the money of the award holder, and subsection 3 only requires that unconditional stay can be granted in the execution petition pending application under section 34, so as to say that still is subject to outcome of section 34. That is how it operates according to my view. Right? Any question? Yes, please. Please.
With the permission of our Honorable Chief Justice, I will request the Shukla sir. Shukla sir has just submitted 100% amount we have to deposit. So if you read these sections, if I am permitted to read, it's being saying upon filing of the application under subsection.
That's Mr. Shukla's suggestion. He's not saying that's what the statute says.
And not we, you are some judicial officer are supposed to do.
If I am permitted to read this subsection,
yes.
Please, it's being upon filing of an application under subsection 2 for the stay of the operation of the arbitral award, the court may, it's being a discretion is being given here, is very court may, subject to such condition as it deemed fit. Means here we don't have to deposit in every matter, we don't have to deposit the 100%.
Unmesh Bhai is the senior counsel, he is not succeeding in this application before these judges. That's why he is making the suggestion.
I'm struggling.
He's struggling. That's why he's making the application. Why else would he do it?
Secondly, in this provision, it is not so on depositing of the award amount. Otherwise, it would have been written on depositing award amount.
Right.
Being a discretion is with the court, 50%, 75%, 100%.
That is always so. That is, we have started.
Facts of the case.
We have started it saying that you have a discretion to pass a conditional stay order. Now, what condition is a suggestion of Mr. Shukla? It is one of the conditions which is there. It is up to the case before the court. Considering the facts of the case, you have to exercise your discretion to grant a stay so as to see that the arbitration proceedings ultimately results in a fruitful proceedings, in a fast track proceedings for which it is meant. So you cannot sit tight over the application of stay for not hearing for 3 years till the 34 is decided. You have to decide the application of stay subject to outcome of 34, laying down the conditions as per your discretion up to case of the which case, particular facts of the each case. So that discretion is there. These are the parameters you have to keep in mind while granting the stay.
And it would help you to know that when Gujarat High Court exercises discretion under Order 41, Rule 5, largely, not in all cases, but largely the High Court orders entire money to be deposited. So if that helps you to exercise the discretion that way, it means that there are others who are doing it.
There are many times we are seeing in the field, poor people who are taking a vehicle loans, all these agreements are coming very, very difficult. For five times they are filing the exam, 5 times amounts are there. Is it possible for them to deposit that amount?
So that is why, that is where you
very difficult. Otherwise, it will be no meaning of court.
What Unmesh is not telling you is that he's got a matter first on board tomorrow.
That is where you have to exercise your discretion.
No, but you have a discretion at least for the principal amount. If you are so poor, you will not loan.
So if I may just briefly supplement, many of these difficult, sticky points can be sort of resolved, at least to some extent, if the rules are brought out pursuant to the power vested in the High Court under Section 82 of the Arbitration Conciliation Act. In AFCON's case, the Supreme Court, which is in 2008, Supreme Court called on the high courts to bring out these rules. And a few of us legal practitioners in the Madras High Court sort of made a nuisance of ourselves. And therefore, the Chief Justice put us as part of the rules committee, the arbitration. And we brought out the Section 80 rules. And we also ensured that they were notified. So if the district judges can bring in their problems with regard to implementation, and if that can, translate to rules, I think you will have some base on the basis of which you can operate.
Friends, I have to excuse myself. Thank you very much.
Thank you.
It has been a privilege.
Thank you very much.
I will see.
Of my Lord Justice Patel's presence and with his insight on this, may we request Honorable Mr. Justice Bhargav Karia to felicitate my Lord Justice Patel, please. Thank you, sir, for your time. Thank you.
Sorry about that.
So let us move to our next topic pertaining to making of an award. Regarding making of an award, Section 31 of the Act provides an important roadmap as to the contents and requirements for a valid award, to the effect that it should be in writing and shall be signed by the members of the tribunal, containing reasons, unless parties agrees otherwise, for award is based on settlement under Section 30, along with date and place of arbitration, providing copy to each part. The importance of reasoned award and legislative rationale of the award is also important from the point of view of Section 34 of the Act. Section 31, subsection 6 provides for interim awards, and subsection 7 creates a dual regime of award of interest. Clause A of Section 31(7) provides that permits the tribunal to grant interest for the pre-award period at a rate it considers reasonable unless the parties agrees otherwise. And Clause B provides for award of interest at the rate of 2% higher than the current rate of interest prevalent on the date of the award till realization unless otherwise directed by the tribunal. The amendment brought with effect from 23rd October 2015 as substituted Clause B, which provided to award interest at the rate of 18% per annum unless the tribunal directs a different rate. Compliance of Section 31 is also important from the perspective of the courts while dealing with challenge to the award under Section 34 vis-a-vis subsection 3 of Section 31, which provides for a reasoned award. An award that is unintelligible or devoid of reasoning may be set aside. Another important aspects of Section 31 is signing of the award, because each party has to sign an award, and as per subsection 5 of Section 31, the Act is crucial for determining the issue of limitation to challenge the award under Section 34 of the Act, because the signing of the award, the limitation starts as provided under Section 34, because the 120 days outer limit is provided under Section 34 so as to challenge the award. Another most important feature for making an arbitration award is regarding awarding cost, which is a most important thing for levy of cost, which is titled as regime of cost. Before 2015, the cost was an issue, but after 2015 amendment has sought to align the arbitration in India with international best practice by moving away from each party bears its own cost culture so as to prevent frivolous litigation by making the parties liable for the full economic consequences of their conduct. Now, any tribunal can award cost to any one party, and by encouraging settlement, so as to encourage settlement to ensure fairness by preserving discretion of the tribunal, by overriding contractual restrictions, by invalidating clause that seeks to predetermined or kept the arbitral cost so as to render complete justice to parties. While awarding cost, most important concept of party autonomy is also required to be kept in mind by the arbitrators, and cost cannot be imposed if the party to the arbitration do not agree to award of cost, which includes fees of arbitration, other cost for conduct of arbitral proceedings. Section 31 capital A also overrides the provision of Code of Civil Procedure by giving discretion to the tribunal to determine the cost by explaining what cost means, reasonable cost relating to fees and expenses of arbitrators, courts and witnesses, legal fees and expenses, administration fees, and any other expenses incurred in connection with arbitral or court proceedings and arbitral award. Subsection 2, 3, 4 of Section 31 capital A stipulates how the cost is to be determined by the court of the tribunal, considering various circumstances enumerated therein, as well as the stages for different modalities of awarding cost. That brings us to Section 32 for termination of proceedings by final award or by any other arbitral tribunal, any order of the tribunal in the eventuality of withdrawal of the claim or agreement between the parties or proceedings become unnecessary, impossible, subject to Section 33 and 34(4) of the Act. This leads us to various questions, which is, there is a long list of questions, but I would like to categorize in 3 points. First, with regard to 31, sir, the issues are which are flags or questions which are posed are like this. While considering the application under section, because 31 has a direct impact on the making of an award, as also the impact on the Section 34. So while considering application under 34 of the Act, how should court draw a line between the poorly reasoned award, an award that is found to be breach of Section 31(3) of the Act? And as a consequence thereof, if arbitral tribunal borrows reasoning from prior judgments or accepts experts' reports without discussion, can that be considered as a satisfaction of the mandate under Section 31(3) of the Act, merely as it is stated in the morning by Dr. Mulidhar of reproduction of the pleadings and then reproduction of the judgments and conclusion, whether it would be hit by 31(3) or not? So these are the 2 main questions in the context of 31 of the Act. Which are the kind of defects that the court can consider as a curable so as to permit the arbitral tribunal to resume arbitral proceedings under 34(4) for remanding the matter of the Act? And whether courts are not supposed to reappreciate the evidence under the Arbitration Act. And yet, when the reasons are thin, isn't there a temptation to step in more deeply? How do we balance restraint with ensuring fairness? And whether this is with regard to the procedure, affixation of digital signature on awards transmitted by eval would be fulfill the requirement of signed award under 31(1) of the Act. These are the pointers under 31. Now, with regard to cost under 31 capital A, the following issues are maybe discussed. How are the arbitration cost and fees to be determined? Because the regime of cost or award of cost is very important while passing an award or making an award. Whether the courts, while considering an application under Section 34 of the Act, has the power to remand the proceedings to the arbitral tribunal to review its award as to interest and cost, etc. or not. Or whether an award or interest as to interest and cost that is found to be in breach of 31 or 31A of the Act is to be treated as being a contravention with the fundamental policy of India as required to be set aside or not. There is often confusion between pre-award penalty, post-award interest. If an interest award is silent, what is the role of a judge to correct for correction, modification, or there should be a remand? Whether courts are required to exercise any extra caution while considering application for setting aside the interim award so as to avoid multiplicity of proceedings. On system, traditionally lean towards each party bearing its own cost. Section 31A signals a different philosophy. So whether this shift is truly reflected in the practice or we still are hesitant to impose the cost, because now in view of this amendment or bringing into statute, what is the effect of 31A while imposing cost and not each party bears its own cost concept, which was prevalent prior to the amendment. Another issue which arises is cost should be reasonable or proportionate. And what should be the criteria or difference or frivolous claim of mere reimbursement, which is passed by the arbitral tribunal? And how should judges measure reasonable cost by the invoices produced or notional scales of fairness, or some report of expert is placed on record and cost is determined on basis of such expert report? When we talk of a cost of arbitration, should this include hefty lawyers' fees and expert expenses, or should be read in section more conservatively? These are on aspect of the award of the cost by the arbitrator under 31A. And another is that whether the 31A court can modify, substitute arbitrator the cost while deciding the application under section 34 or not. Because more or less this 31 has a directly implication on the decision of 34. So we have is overlapping on the exercise of the powers of 34 of the act also. So under section 32, how does a moratorium with regard to section 32, sir, of awarding of this insolvency or bankruptcy impact the continuity of arbitral proceedings? Would the same result in termination as contemplated under section 32 of the Act or not? Or where a claimant withdraws midway, does the section 32 compel termination of the entire proceedings, or can the arbitral tribunal still remain jurisdiction over live counterclaims? If the parties compromise privately and inform the tribunal, is it better practice of the tribunal to simply terminate under section 32, or should it insist for recording settlement under section 30? If tribunal proceedings are stalled by non-payment of fees, is termination the only remedy, or courts can intervene? And the Act uses broad terms like unnecessary or impossible as grounds for termination. Should tribunals supervising courts construe these words narrowly to preserve adjudication, or expensively to cut short the futile proceedings? These are the issues under section 32 for termination. So over to you, sir, on such aspects. Yes, sir.
Honorable Chief Justice, the Honorable Judges, Judicial Officers, Senior Advocates, and my dear friends, I thank the Honorable Chief Justice for giving this opportunity. Sections are very small given to me, but queries are much more than the size of the section. So I'll try my best to resolve all the queries what is possible. First is about the procedural aspect under section 31, which is very crucial. I'll go one by one. Award has to be in writing and signed by all the arbitrators. If there is a sole arbitrator, of course, he has to sign the award. But what happens if there are 3 members tribunal or 5 members tribunal? So the requirement is that majority of the arbitrators should sign, provided the reasons are recorded in the award why the other arbitrator who has not signed, why he has not signed. There was a situation before Bombay High Court in one of the matter in case of Ashish Busa versus Atul Gandhi, 2019 SSC Online Bombay 1102, where third arbitrator had not given any dissenting award also, and he had also not signed the award. So that award was challenged. The 2 arbitrators were asked to file an affidavit why there is no signature of the third arbitrator on the award. So majority of the arbitrators produced an email from the third arbitrator confirming that he had participated in the arbitral proceedings and he agrees with the view taken by the majority arbitrators. So considering that email on record, the High Court took a view that this was in substantial compliance of the requirement of section 31(1). Another crucial part is about the reasons. We have discussed it since morning number of times. Reasons are treated as heart in a body, heart of a judgment, heart in the award. What is the purpose of reasons? I must tell you, under 1940 Act, the language was that arbitrator is not bound to give reasons unless otherwise provided. Under 1996 Act, arbitrators are bound to give reasons unless otherwise provided. So unless parties agree that all that, let the arbitrator have summary power and he should not give reasons. Otherwise, he is bound to give reasons. The purpose of reasons are that if you challenge it, the party challenging that award under Section 34, he has to make out a case that his petition falls under one of the grounds of challenge under Section 34. If there are no reasons, court cannot decide under Section 34 whether right award should be set aside, and if set aside on what grounds. One of the interesting situation arose before Bombay High Court. I was party to that judgment. The reasons were not sufficient given by the arbitrator. So award was challenged on that ground, and respondent was trying to struggle with the court that look, there are so many other reasons on which the arbitrator would have allowed this claim. So question arose that whether those other reasons which are not given by the arbitrator, whether should be read into the award by Section 34 court, whether Section 34 court can supplant the reasons in the award and thereafter take a view one way or the other whether award should be set aside or not. Answer is no. Whatever reasons are there, reasons have to be considered. At this stage, I must also deal with one of the query about sufficiency of reasons or poor reasons given in the award. If reasons are poor, are not intelligible, you can't make out what does he want to convey. In that event, remedy is now available. Now Supreme Court recently in case of Gayatri, 5 judges bench have taken a view that court can remit the matter back for rendering reasons under Section 34(4). Because 34(4) says that to eliminate grounds of challenge, court has ample power instead of setting aside the award, let it go back to the arbitrator. Though the earlier view in Kinnary's case, Supreme Court had taken a view that Section 34 court has no power to remand the matter back to the arbitral tribunal. Either you can set aside the award or you can appeal the award on the basis of the view taken by Supreme Court in case of McDermott versus Bund Standard, where the view was that court cannot correct the error of the arbitrator. Court can either set aside the award or court can uphold the award. In case of Somdat Builder versus State of Kerala, 2009 10 SCC 259, it was held that if arbitral tribunal does not give reasons under Section 31(3), the court can pass an order under Section 34(4) and can allow the arbitral tribunal to give reasons. Another aspect about reasoning is that it should be clear an arbitrator is not expected to write a judgment, what is expected under CPC. Arbitrator is deciding basically the issues raised before him. He has to disclose his mind because court cannot probe into the mind of the arbitrator. Therefore, arbitrator has to disclose his mind and come to the conclusion that for what reason he has come to a particular conclusion. 31(4) talks about date and place of award. So in the arbitral award, arbitrator has to put the date as well as the place of signing of the award. One of the judgment of Supreme Court takes a view that the purpose of mentioning the place of award is that if there is no seat of arbitration decided by the parties in the arbitration agreement, then where the award is signed, that becomes the seat for the purpose of jurisdiction under Section 34 and all other purposes. Another very crucial section which all the judicial officers normally face the problem while considering an application for execution. That is under Section 31(5). 31(5) says that signed copy of the award has to be delivered by the arbitrator to the parties. So what happens if it is not delivered? Only one party has received. Party who has succeeded, he must have received a copy of the award. The other party who is not paying fees of the arbitrator may not get copy of the award. So what happens in this type of situation? whether limitation starts or not. So arbitrator can't withhold with the award, according to me. He can claim a lien because his remedy is available and intact under section 38. If matter goes to the court, you can file an application before the court, or you can make it as part of the award that one of the party has not paid his fees. The other party who has succeeded before you will point out to the court that arbitrator's fees is also not paid. Perhaps court may pass an appropriate order for taking care of the arbitrator's fees. There are different situations when it may amount to good service. As all of you know, under CPC, there are various judgments. Section 27 of General Clauses Court is considered in series of judgments. What happens in case of a registered AD, notice sent by registered AD? There are few judgments considering section 3(1)(b) of the Arbitration Act when it amounts to service. In case of Union of India versus Teco Engineers and Contractors 2005 4 SEC 239, Supreme Court has held that delivery of an arbitral award under section 31(5) is not a matter of mere formality, it is a matter of substance. And why it is matter of substance? Because various periods of limitation starts from the date of service of copy of the award. It is not sufficient that only one party is served and that party calls upon the other party to comply with the award. The Supreme Court has gone to the extent of saying that even lawyer is not an agent of the party, or even a lawyer is not an agent for accepting service of the award. Of course, if he gets an authority in writing from the party that let him receive award on my behalf, then it is a different situation. Otherwise, copy of the award has to be served upon the party. Limitation under section 33 for correction of an award starts from the date you get copy. Under section 34 for challenging an award, when you get a signed copy of the award from the arbitrator. Now, why it is important for all our judicial officers and those particularly who are going to deal with the execution application? Because one party files an execution application before you, because under old Act, 1940 Act, all papers were required to be filed by the arbitrator in court under section 17. Under 1996 Act, arbitrator is not bound to file papers and proceedings in court upon completion of arbitration proceedings. So there is no procedure of notice by court under section 17(1), which used to be earlier. So one party who has received copy of the award, he will wait for 3 months and he will file an application for execution. Other side who has not received copy of the award, when he is served notice by the executing court, he will come running and he will say that, sir, I have not received copy of the award. How to verify this situation? Because if signed copy of the award is not received by one party who is aggrieved, then his limitation to challenge that award under section 34(3) will not start. If limitation is not over, there is no question of enforcement. Therefore, section 36 will not come in operation. So when that is the situation before you, what you can do is you can direct the arbitral tribunal to file records of the arbitration proceedings before executing court to find out whether service is complete or not, or whether service is refused. Now, what are those circumstances in which various courts have taken a view that it will amount to good service? I'll just very quickly, in 3 minutes, deal with those judgments for your benefit. Delhi High Court in case of Ministry of Health and Family Welfare and another versus HOSMAC Project Division of HOSMAC India Private Limited 2023 SEC Online Delhi 8296 held that expression party does not include an agent or a lawyer of such party. Delhi High Court in another case, in case of Ministry of Youth Affairs and Sports and Ernest and Young 2023 SEC Online, Delhi 5182 has held that delivery is validly satisfied by sending a scanned signed copy of the award to the parties via email, provided that email is an accepted mode of service between the parties and the tribunal. Supreme Court in case of Parmeswaram Unni versus G. Kanan 2017 5 SCC 737 on examining the provisions of Section 27 of the General Clauses Act read with Section 114 of the Evidence Act held that when a notice is sent by registered post and is returned with postal endorsement, refused or not available in house or house locked or shop closed or address is not in station, due service is required to be presumed. In case of Priyanka Kumari versus Shailendra Kumar 2023 Supreme Court Online Supreme Court 14329, Supreme Court has held that when a notice is served at the proper address of the addressee, it shall be deemed to have been served unless the contrary is proved. If a notice is returned as unclaimed, it shall be deemed to be served and constitutes proper service. Bombay High Court in case of Francisco D'Souza versus L&T Finance 2015 3 OLMR 803 has construed Section 31B of the Arbitration Act 1996 and Section 27 of General Clauses Act and held that since the award was sent by registered post to the petitioner's last known address and was not returned, service was deemed to have occurred. I had occasion to decide this issue before the Honorable Bombay High Court, where in case of a finance company, you will get this problem most of the time, that the borrower, he gives a particular address to the finance company. After taking loan, he will change his address and he will not appear because notice will come back, left, closed, all sorts of endorsements by the postmaster. So question arose that whether in this type of situation, whether it will amount to good service or not. The Bombay High Court took a view that you have changed your address, therefore it was your duty to brought on record the new address, current address to the borrower so that he could have served the papers and proceedings at the current address. If you have not done that, for whatever reasons, it will still amount to good service. In case of Genjon Retail and Services Private Limited versus Lavasa Corporation Limited 2016 Supreme Bombay 767, Bombay High Court dismissed the petition as time barred, establishing that an unclaimed service of an arbitral award constitutes a valid and deemed service which effectively starts the limitation period. You will come across an intimation. Postmaster will go to your premises. 3 times you are not found there. He will drop one intimation that you come and collect your post within 1 week from the post office. So you don't claim, say, I don't want this. I will not collect also, and at the same time I will not receive it also. So even unclaimed service also amounts to good service. The same view is taken by Bombay High Court in case of Jaswinder Kaur versus Pradeep Singh, widow Pradeep Singh versus L&T Finance. About interim award under Section 31(6). In one of the interesting matter before the Honorable Supreme Court, application was filed that the claims are barred by law of limitation under Section 16. The Honorable Arbitrator took a view that no, claims are not barred, claims are within time. So that decision of the arbitrator was not challenged under Section 34 within 3 months from the date of getting signed copy of the award. Honorable Supreme Court took a view that this was an interim award. Therefore, you ought to have challenged that award within the same time prescribed under 34(3). You could not have waited for the final award. So this is about the interim award. Interim award can be made in respect of any claims where you can make final award. Sometimes parties themselves will tell the arbitrator that, and more particularly in case of a construction contract, where there are different varieties of claim. One claim may be relating to the final bill, where work done is the claim. Other sets of claim may be by way of damages. So if there are certified bills, both parties may request the arbitrator that all right, you make interim award as far as final bill is concerned, because that will carry some interest. And if we wait for 2 or 3 years for completion of arbitration proceedings, there will be huge interest burden. So there in arbitration of arbitral award in interim can be made. That will have same period of limitation. You can challenge that. And once that part of the award attains finality and your petition under section 34 is dismissed, there is no question of challenging that award again under section 34 along with final award. Bombay High Court in case of Spear International versus Ecopack India Paper Cup Private Limited 2019 SEC Online Bombay 1490 has held that if there are serious disputed questions raised by the respondent in the arbitral proceedings about the claim made by the claimant, which requires detailed evidence at the stage of trial, the arbitral tribunal cannot exercise its discretion under Order 12, Rule 6 of the Code of Civil Procedure and make any interim award. So in that type of situation, you can consider all the issues and make a final award. The next component of section 31 is award of interest, which is again very crucial. There is some discussion already made earlier. So under 1996 Act, because of 31(7) now, arbitral tribunal has been empowered to award interest for all periods. It is inbuilt provision now from the due date till the date of award under 31(7)(a) and under 31(7)(b) for post-award interest. Prior to 1996, the interest element was demanded and awarded by the arbitrator under 3 different heads. Some part of interest under CPC, some part of interest under the provisions of Interest Act 1978. All those provisions are now given a go by because of the inbuilt power under section 31(7)(a). Supreme Court in case of Palm Developers versus State of West Bengal has held that arbitrator has authority under section 31(7) to award pre-reference period interest unless the contract prohibits it. Courts and tribunals have to examine contract clause in proceedings concerning arbitration. Now, before I go to the other judgments, I must also share with you 31(7)(a) says that unless otherwise agreed. So if there is a prohibition under the contract that no interest will be payable, you will find some such type of clauses in the government contracts or railway contracts where you will find that interest is not payable. If that is so, then arbitrator is also bound by the agreement between the parties, not only the parties. In that event, he cannot award any interest in view of in the teeth of prohibition, but up to the date of award, not post award. I'll share with you that judgment also. Secondly, if agreement provides for particular rate of interest, it may be 6%, it may be 25%, it may be 36%. If agreement provides, then arbitrator is bound to consider that agreement. He can't say that rate of interest is on much higher side. Therefore, I will try to be reasonable. I will make it 50-50. He can't do that. Supreme Court in case of RP Garg versus Telecom Department 2024 SEC Online SC 2928 has held that post-award period shall carry a rate of interest decided as per section 31(7)(b). Even an agreement between the parties not to grant post-award interest cannot eliminate the statutory right to award post-award interest. Now, prior to 2015 amendment, 31(7)(b) was that if future award interest for future award is silent about the future interest, that means from the date of award till payment, then what is the remedy available? What is the entitlement of the successful party? The unamended section provided that in that event, future interest is to be paid at the rate of 18% per annum. Unless the arbitral tribunal has rejected the claim for future interest or has provided a particular rate lesser than that. So many times you will find that arbitrator will be silent about future interest. So 18% interest, which is impossible now, even fixed deposit doesn't give more than 7 to 8%. So because of that, there was an amendment under 31(7)(b), and the amendment was that if the award is silent in that event, 2% more than the highest current rate of interest on fixed deposits, that is under the provisions of Interest Act 1978, will have to be read as the future interest. Supreme Court in case of UHL Power Company Limited versus State of Himachal Pradesh 2022 4 SAC 116 has held that arbitral tribunal is empowered to grant compound interest. Arbitral tribunal may award interest on the sum directed to be paid by the award, meaning a sum inclusive of principal, sum, adjust and interest. Constitution bench in case of Gayatri Balasamy versus ISG Novasoft Technological Limited 2025 INSC Supreme Court 605. This is while dealing with one of the query that if award is granted on lower side by the arbitral tribunal, then what happens? Because of the judgment of Supreme Court in case of McDormand versus Bund Standard, the view was that court cannot correct an error of the arbitrator. Means if your claim is fully rejected or your claim is partly rejected, court under section 34 cannot grant you that relief. By granting you larger relief which you were seeking or by granting more than what was granted to you. Supreme Court now in this matter, Constitution bench has taken a view that court has limited power of modification. That limited power of modification, if you read the judgment, it says both ways. But as a student of law, what I understood is court has power to remit the award under section 34(4) to the arbitral tribunal. And in certain cases, if there is injustice to a party where lesser rate of interest is awarded, suppose contract rate is 12% and arbitrator is granted 6% only. Now what to do in this circumstances? Can you set aside the award and send back the party to arbitration for additional 6%? Supreme Court has protected that situation, that can be taken care of by court under section 34. Then about cost of the arbitration, this is again a very burning topic because I have experience of both sides now. In last 2 years, I have seen the arbitration cost. 31(8) has to be read with 31(a) as to what should be considered by the court while considered by the arbitral tribunal while considering a claim for cost. Explanation to 31(8) says that definition of cost, the term cost encompasses reasonable expenses relating to arbitrator fees and witness expenses, legal fees and expenses, administrative fees of any supervising institution, and any other expenses incurred in connection with the proceedings and the award. And discretion granted to the court under subsection 1 is that tribunal possesses the full discretion to decide on all aspects of cost, specifically liability for cost, quantum of cost, timing of payment, factors to be determined while deciding the cost under 31(a)(3), conduct of parties, partial success, frivolous claims, settlement refusals, etc. So I must share with you in the very high stake arbitration in Bombay particularly, peace has reached between 5 crores plus. And what happens is that before the arbitral tribunal, parties have to file statement of arbitration cost. So that time you come to know that what arbitrator is charging and what parties are charging, while councils are charging. You will be dealing with section 34 petition, and one of the grievances that claim was 5 crores and cost is 4 crores. So what do you do in this situation, and what will poor arbitrator do? He knows to the extent what is paid to him. But in the statement of cost, you will find 3 councils, 6 junior interns also attended the arbitral proceedings. For every small thing will be part of the arbitration cost because it permits arbitration fees and witness expenses, legal fees, administration fees of any supervising institution, and any other expenses incurred. Now, any other expenses is a blank check given to you. So, question arises for an arbitrator, they have to ask parties to produce the proof of all this. Because normally when statement of cost is filed, they only give a statement under which head how much amount is paid, and then you have to decide. So one party is dishonest. Court arbitrator comes to the conclusion that the claimant is honest. He was required to invoke arbitration proceedings because of the dishonesty of the respondents. Yes, you exercise your discretion. Who has delayed the proceedings, you exercise, consider that aspect. So conduct of parties and the party who has succeeded is most crucial while exercising discretion under 31A. About cost, arbitration cost, before I go to the proceedings of termination, I was just thinking overnight yesterday that why Justice Karya has included section 32 with 31A. What is the reason for that? What termination of proceeding has some connection with the arbitration cost? I said, no, this is not accidentally, but it is with something in mind. So I am just trying to read his mind that considering the heavy cost of arbitration today, where crores of rupees are involved, required to be paid to arbitrators or to the council, and when there are big solicitors involved, then still amount may be still multiplied. So initially, when the arbitrator is appointed, unfortunately, nobody tries to dare and try to bargain with the arbitral tribunal. The impression of the parties and advocates is that if you try to bargain with the arbitrator, his mind will be prejudiced and he will decide against you. In that type of situation, what to do? So you talk to your advocate. Advocate, તમને કહેશે 25 ચલાવવા દે મેટર. સાહેબ ગરમ થઈ જશે તારા અગેન્સ્ટમાં કરશે. માઇન્ડ પ્રિજુડિસ નહીં કરવાનો ક્યારે પણ. So because of this, lawyers will say that you will have to pay my fees also and arbitrator's fees also and all expenses also. Because under 31A, everything is permissible now. You will claim everything. Don't worry. Keep on continuing. So one of the ground of termination under section 32, I'll just quickly read, is conclusion of final award. Proceedings can be terminated. Conclusion by tribunal order. Proceedings can also be terminated by formal order issued by the arbitral tribunal under the authority granted in subsection 2. And even by, if the claim is withdrawn, then what do you do? Claim is withdrawn. So several matters are settled in Mumbai. When parties realize that now it is enough, we can't, our full pocket is full of holes. We can't afford to pay advocates' fees and arbitrators' fees. And arbitrator has already made program for his foreign visit with his family. And all of a sudden you will find an application by both the parties. Sir, we have withdrawn our claim. We will be anxious to know what happened, how you withdrawn, who is getting what. He says, sir, તમને બતાવવાની જરૂરત નથી, અમે કરી લીધું. અમને નથી ભાવતું, હવે તમને પરવડતું નથી તમારી ફી આપવાનું. So we are withdrawing our claims and counter claims. The view taken by Supreme Court is that if arbitral proceedings are terminated, in that event, you can't recall that order, arbitrator cannot recall that order. At the same time, this will not amount to an award, and therefore it can't be challenged under Section 34 of the Arbitration Act. The 2 or 3 queries I'll try to resolve from here. One is about curable award, curable defect. That I already told you. Gayatri's case, Supreme Court takes care of that. You can remit the matter to eliminate the grounds of challenge, that is 34(4). Affixation of digital signature, again, it can be done. About IBC, one of the query was about insolvency in bankruptcy court. Just please repeat now that query if you don't mind. Okay. So thank you very much for giving this opportunity.
Thank you, sir. This brings us to the next two left out subjects. One is with regard to the enforcement of the International Arbitration Awards. New York Convention versus Geneva Convention, which we can skip because we are not concerned with.
I would be happy.
Yeah, he would be happy.
I'll tell you one thing.
Because ultimately, we are not to deal with those issues.
If I were a district judge, I would say go to High Court.
Go to High Court. That is one liner is enough. So we, as a High Court, will take care of it. Now the question is of subsection 40, section 42 and 43. I request Mr. Raja to address us.
Honorable Chief Justice, brother and sister judges of the Gujarat High Court, Honorable Solicitor General who is here, my friends, co-panelists in the committee, I can sort of read the mood of the audience, and I can also, and from a very young age, I can read the clock, so I know it's close toward the tail end of the proceedings. So I'll try not to detain you for too long. Section 42, 43, very quickly. Section 42, it's always said that the person who does not know the reason behind the law does not know the law. So the rationale behind Section 42 has been summed up by the Supreme Court in Bharat Aluminium Company versus Kaiser Aluminium Technical Services as far back as 2012, and again reiterated in the case of BGS SGS Soma JV versus NHPC Limited. Mark Twain said that war was invented for Americans to know geography. So I think arbitration is invented for Indians to learn some nice names, foreign names. So this BGS, SGS, Soma, the Supreme Court held that the purpose of Section 42 is to see that there is that the multiplicity of proceedings is avoided. That's the purpose of Section 42. So whenever interpreting a section, it is fruitful to first look at what it seeks to do, and then all further actions, if it is channelized towards that objective, then the section serves its purpose. So the purpose, as I said, is to ensure that multiple courts are not seized of the same matter, leading to multiple conclusions and multiple awards, and a confounding situation does not arise, and therefore Section 42. So the first point to be noted about Section 42 is that
everything follows the first application. But then the first application itself must be filed before a court of competent jurisdiction. If the court that is seized of the first application is a court that does not have jurisdiction over the matter, then you cannot plead section 42. The second important point to note is what provisions of the Arbitration Conciliation Act are subject to section 42 and what provisions of the Arbitration Conciliation Act are not subject to section 42. The provisions which to which section 42 applies, I'm not going to take you through the long line of cases which decided these various points, but today we can safely assert that section 9, section 14, section 34, section 27, and in related application section 37, section 42 will apply. The provisions to which section 42 will not apply are sections 8, section 11, and section 36. So primarily, therefore, we know that we cannot allow a party to invoke section 42 when a section 11 or a section 8 application or a section 36 application is argued before the court. Now, what is the controversy with respect to its application to execution proceedings? Now, in the first case where this issue came up, West Bengal versus Associated Contractors 2015 1 SEC, the Supreme Court said that section 42 will apply to applications made after the arbitral proceedings have come to an end, provided they are made under Part 1. So this is a very, very wide statement of the court. This was used in subsequent proceedings to argue that execution proceedings will not you cannot file execution proceeding in a court different from the court to which a section 42 provisions apply. But Sundaram Finance Limited versus Abdul Samad in 2018 3 SEC, page 622, the Supreme Court negatived this argument and said no, execution proceedings fall under a completely different class because the arbitration proceedings themselves have come to an end. And your section execution proceedings start after that. The provisions of section 42 therefore applies while the arbitration proceedings are on. So you cannot apply the provisions of section 42 to an execution proceeding. Thankfully, this was followed in Charan Properties Limited versus Kasturi and Sons Limited in 2018 16 SEC, page 413. So, and on account of that, thankfully, the Allahabad High Court in MBBNL versus Sasi Cables, NHAA versus Jagpal Singh, Delhi High Court, Rama Civil Constructions versus Union of India, Delhi High Court, Vijay Gupta case, once again, Delhi High Court. All these cases affirm the principle that in respect of execution proceedings, this will not apply. What has caused a bit of a confusion are the judgments of the Telangana High Court in India Media Services and Pipeline Infrastructure, which are recent judgments, which is 2022, where they have said, please look at Sundaram Finance case. That was a case relating to section 34, and therefore you cannot apply the rationale of Sundaram Finance case in respect of applications under section 9 or any other application, section 40. Now, this caused a bit of consternation, but thankfully, this is only at the Delhi High Court level, and other high courts have not followed this judgment. Now, the second aspect comes in with regard to seat. What is the seat? Now, the problem happens to be the court's agony with deciding what is the seat of an arbitration flows from ill-drafted arbitration clauses. That's a problem. Because many arbitration clauses have a provision which says that the seat of an arbitration will be a particular place, but then immediately after that will follow a provision which says that for all applications in respect of this agreement, the courts in a particular place will have jurisdiction. So this was a bit confounding because then the courts were left to wonder, now what will be the seat? Supreme Court has clarified that, and also various high courts have said very clearly the seat, venue, place, these distinctions today will stand obliterated. Because under the provisions of the Arbitration Conciliation Act, there is no mention of seat, there is no mention of venue. There is mention of place, the mention of place is in section 20. So ultimately, all these move towards a point of convergence. And today we have a legal position by which if the agreement states that the venue, seat, place is a particular place, then all applications will be filed in the court which has jurisdiction over that seat venue place. So this is again something when I was part of the 246th Law Commission Deliberation Committee, and the 246th Law Commission put this in perspective and said, please make these amendments, define seat, define venue, and all these were given by us in the Law Commission report. If you read the 246th Law Commission report, it very clearly says that. But the legislature preferred politeness to clarity, and therefore on account of that, they said that this has already been decided by the Supreme Court and we do not want to revisit the issue, and therefore let it, in a way they are correct also, because if you bring in an amendment, then the question arises whether this amendment overrules the Supreme Court judgment. It leads to a whole lot of complex questions. So the legislature left it at that and said that it's already been stated very clearly that seat venue plays through various judgments. Let us go by judicial interpretation. Let's not introduce any amendments to any statutes. Now, this is the situation today that we are in with regard to place, venue, and its application to Section 42. Now, coming to limitation, I have quick 10 points to make. Point number 1, Section 29(2) of the Limitation Act blesses limitation provisions in other statutory provisions and says when other statutory provisions make provision for limitation, that will supersede the provisions of the Limitation Act. So that's where the blessing for the various timelines that have been set out under the Arbitration Act comes from. Second, the sticky question for a long time was, what is the limitation for Section 11 application to be filed? That has now come to be decided in Geo Miller case, where the Supreme Court says it's the same, and the residual provision of the Limitation Act, Article 137, was applied to say that it is 3 years, and the Supreme Court also says that this is not a very salutary thing, because you can't have 3 years. I have a question that arises on account of this. If you see Section 9, if you file a Section 11 application without a Section 9 application, probably Geo Miller is right. But if you look at Section 9 of the Act, it has a provision which says that if you get an interim order, then you are bound to file a application within 90 days. Now, if you don't file it within 90 days, what happens? I mean, then is that a limitation? Is that a period of limitation, or is that only recommended? Now, that is a question which has not come up before any court for consideration. 9(2) says where before the commencement of the arbitral proceedings, a court passes an order for any interim measure of protection under subsection 1, the arbitral proceeding shall be commenced with a period of 90 days from the date of such order or within such further time as the court may determine. So I am yet to see an application filed by court. Please correct me if I am wrong, but I am yet to see an application filed by the court which says that I got this interim order on such and such a date. Within 90 days, I ought to have filed a Section 11 application. I have not filed a Section 11 application before that time. Kindly condone the delay for filing my Section 11 application. I am yet to see an application under Section 11, which is control delay application attached to a Section 11 application. So what is the position on that? Or do we treat this provision under Section 9 as a period of limitation, or is it only like Salem Bar Association? Shall we invoke Salem Bar Association to say that all these timelines are only recommendatory and are not mandatory? I think ultimately the courts will be constrained to say that please take the line of Salem Bar Association and don't treat this as a point of limitation. The third point is what is the limitation? What is the starting point for an arbitration claim? Now that has been clarified, and it has said that the same starting point for a suit is what that will apply to an arbitration claim also. Likewise, in respect of a counterclaim, that's my fourth point. My fifth point is Section 13(2). 13(2) contemplates, if you see Section 13(2), it actually contemplates two classes. Failing any agreement referred to, a party who intends to challenge an arbitrator shall within 15 days after becoming aware of the constitution of the arbitral tribunal or after becoming aware of any circumstances referred to in subsection 3 of Section 12, send a written statement of the reasons for challenge to the arbitral tribunal. So what happens? I don't do it within 15 days. What happens? are we once again to take this as recommendatory or mandatory? Because please see, both in section 9 and in section 13, the word uses shall. Of course, judicial interpretation says if the word shall is used without spelling out the consequences, if that is not being adhered to, then it should be treated merely as recommendatory and shall not be treated as mandatory. If that norm of interpretation is applied, both these will have to be treated as recommendatory. But I think it is also important to understand that if this objection is not made within 15 days, the court has the right to close that unless for any supervening reasons, it can establish that an application could not have been filed within that time. Then, section 34 has led to a bit of a sticky problem because section 34 talks about 3 months as being the time limit for setting aside an arbitration award. But quite astonishingly, many courts say 90 days. 90 days is not 3 months. 3 months is not 90 days. Section 335 of the General Clauses Act defines a month to be a month according to the English calendar. So there can be situations where you have a 3 month and have 91 days and you file it on the 91st day, the court says 90 days and kick out your application. So this is again a sticky point as far as limitation is concerned. So courts have been using the words 3 months and 90 days interchangeably, probably requires a revisit. The 7th point that I'm making is section 43.3, which is within the province of what has been assigned to me, is 43.3 within is legal at all. 43.3 says where an arbitration agreement to submit future disputes to arbitration provides that any claim to which the agreement applies shall be barred unless some step to commence arbitration proceedings is taken within the time fixed by the agreement and disputes arises to which the agreement applies. The court, if it is of the opinion that in the circumstances of the case, all this why? Because under this, if you have a clause in an arbitration agreement which provides for a shorter period than what is permissible under law, I presume that it will fall foul of section 28 of the Indian Contract Act. So why are you providing time in 43.3 for an extension of a provision which section 28 of the Contract Act declares to be void? So that is again a question. Kerala High Court has said that yes, you cannot, this doesn't apply at all. It is in violation of section 28 of the Contract Act. I haven't seen any other judgment to that effect. Then section 2.4, what is the impact of section 2.4 on section 43? Section 43 says, 43.4 is very important, where the court orders that an arbitral award be set aside, the period between the commencement of the arbitration and the date of the order of the court shall be excluded in computing the time prescribed by the Limitation Act. Very well. But please see 2.4. 2.4 excludes section 43 for the purpose of statutory arbitration. Under section 2.4, this period, section 43 is specifically excluded. This part, except subsection 1 of section 40, sections 41 and 43 shall apply to every arbit except these 3 sections. So 43 is excluded. So let us take a situation where as an MSME contract, there is an arbitration clause and then it culminates in an award and that award is set aside. It's a statutory arbitration. Award is set aside. Now, it takes about 4 years for the award to be set aside. Now, by application of section 43 and read with section 2.4, it means that the provisions of section 43.4 will not apply because section 43 has been excluded. So what happens in all these matters, the subsequent claim, what is the option for a person where the arbitration award has been set aside, he has to start from scratch. And if he goes back and tries to start from scratch, this provision can be put against him to say that, no, I'm sorry, because section 2.4 says section 43 is excluded. That is another point which may come up before court on subsequent occasions. I'll start with section 29A. 29A sets out the, it has a very salutary and a very noble purpose. It says, I mean, it goes towards trying to see that arbitrations are completed within a given period of time. But once again here, the arbitration
the timeline start kicking in after the pleadings are completed. So what if I face this problem as an arbitrator? Parties do not conform to time limits that we set for the pleadings to be completed. And if that's going to go on endlessly, what power does the arbitrator have? And what is the meaning of these limitations? Because if your period of 12 months is going to kick in after, and there is no need to file an application. If the period contemplated under 29A expires, then you need to approach the court for extension of time. But as far as pleadings are concerned, it is left to the arbitral tribunal to decide. And therefore, what is the period of, how do we reconcile this and still make the arbitration proceedings speedy and effective? So these are my thoughts on this. Thank you for giving the opportunity. And I hope I haven't detained you for an unnecessarily and unreasonably long period of time. Thank you.
No. Thank you so much. Now that brings us to the end of this second session, subject to, because whatever questions which were posed by you online have been already answered, as I presume by Mr. Raja. I now request Sri Tushar Bhai to grace the dais and for the way forward. Please, that is, you come here. Here is wherever it's better to be here if you decide now. Whatever. Okay. Thank you.
Honorable Chief Justice, Honorable Judges, my dear colleagues, Manisha Lavkumar, the learned Additional Advocate General of Gujarat, and all future lordships, as I always address them. If you have seen the program schedule, everyone must have seen. Every program, every session has an end point. The last program is 3:30 p.m. onwards. So technically I am entitled to speak as much as I want. Before I begin, આરોપીને જ્યારે મૂંઢ મારવામાં આવે ને પછી એને મેજિસ્ટ્રેટ સામે રજૂ કરવામાં આવે અને મેજિસ્ટ્રેટ એને પૂછે કે કોઈ તકલીફ પડી, એટલે બિચારો ડરના કારણે કહે કે ના નથી પડી. તમારી બધી તાળીઓમાં એ મૂંઢ મારનો આર્તનાદ એટલે I'll not take much, and all learned things are said by all people who are really learned. They are all domain experts, they are subject experts, and the subject given to me is also way forward, meaning thereby I am not supposed to touch anything which is already said and which is already done by the country. So I'll be very brief. I only want to address on 75 points, out of which 70 are not relevant. So that leaves me with 5 points. Now, first point, when we say way forward, we will have to analyze, and something which is not done in our country, as to whether we have, where we have reached. When we say way forward, necessarily mean that we started from here, we reached here, and now this is the way forward. There is no systematic study done as to how arbitration as a concept of dispute adjudication has succeeded, if at all it has succeeded in India, or it has failed, or it has partly succeeded and it has partly failed. Now, one of the tests of the success or a failure of any particular system of adjudication is whether the litigant, the beneficiary of the system, or the consumer of the process, if I use the word loosely, is happy with the system or not. I don't think there is any study conducted which can give us an empirical data that those who are stakeholders are, whether they are satisfied or not. And if we go by one suggestion or one action, the government of India had to take a call, a policy call, that in all contracts involving more than 10 crores, we shall not have an arbitration clause. It's an alarming decision. And irrespective of any empirical data, it speaks volumes. And I would address in a very brief time what can be the possible reasons and what can be the possible solutions. At the outset, I put a caveat that the Government of India is in the process of making some amendments in the Arbitration Act, and I am playing a very little part in that. Therefore, whatever I say today are my personal views as a student of law, as a lawyer, not views of the government. The real problem which is faced by the arbitration community in the country, I do not know whether that problem is shared by the Gujarat litigants or not, Mr. Shukla or other seniors can say, is the question of integrity of the process. And when I say integrity of the process, I will not mince words. I say integrity of the arbitrators. Very few people touch this subject because it's not popular to touch this subject, but unless and until we touch the problem, we'll not be able to reach the solution. And the real reason is the integrity. Now, integrity is something which is inherent in any human being. Integrity can never be regulated by making any statutory provision. Integrity can only be regulated by making some amendments or some statutory provisions which keeps a check. Why would a litigant like the Government of India or public sector undertaking choose to go before the regular court of law, though it takes time, it's a time-consuming process. You go from district court to high court to Supreme Court. There are interim orders and revision and appeal from orders. Everything is acceptable, but for arbitration. People they take that chance because there is a system in place which ensures that the judge concerned will not, in legal sense, misconduct himself while discharging his judicial functions. Whether we are able to give that confidence to the litigant that yes, you have a different, faster, effective alternative dispute resolution mechanism and you can trust. Unfortunately, there have been instances, and I am privy to many instances where the integrity was not even doubtful. This is the reason why there is a reluctance even amongst some corporations, statutory corporations and some big companies who do not believe in any other method of approaching the arbitrator. And once I have even said before a constitution bench, while arguing a matter of arbitration, that government does not have a level playing field against a private individual, and level playing field speaks volumes. That is first issue. Now, there was a solution. The solution was that suppose there is a public sector undertaking, the public sector undertaking would do the due diligence and select arbitrators which are unimpeachable in terms of integrity and character, and ask the other side that you select any one of them. We have a list of 50 arbitrators. There are 50 honorable judges, 50 engineers, 50 other domain experts. It's a huge pool out of which you can select one. One I will select as a public sector undertaking, one you select. Now that came to be in question, in care judgment. Everyone must have not. I don't wish to cite any judgment. It's a 5-judge constitution bench, and we lost. I happened to argue, and we lost on that. That you must give an option to the litigant to choose his arbitrator. The arbitrator has to be arbitrator of his choice. So that, of course, that is for the parliament to take a call. I do not know whether parliament would take a call on that or not. Second option, which is in my mind, and I am saying this as purely my personal view. Those who are practicing in the field of arbitration tells me that from the name of certain arbitrators, you can find out the firm which must have engaged him and the litigant which must be the client of that firm. Now, you cannot do anything about this. This is a system, again, integrity can never be regulated by statutory mechanism. But there is one solution which can perhaps be a solution, if at all. And that solution is make it mandatory by law that all awards given by all arbitrators in all arbitrable disputes will be published on one site. You will come to know which company engages which arbitrator very frequently and which lawyer represents that company before that arbitrator almost frequently. This would work as a check. I'm not being skeptical. I'm not being critical. I'm not being bitter. But unless and until you go to the root of the matter, which shows us that there is a reluctance slowly stepping in, we will not be able to find a solution. And unless and until we find a solution, convincing people that arbitration is a better option than the regular conventional litigation, it would be difficult for our courts to manage the heavy backlog which is troubling the entire nation. Now, another problem which is being faced, and I am on the way forward part. The arbitrators are very busy. Many arbitrators are doing 3 arbitrations in a day. Earlier, we used to have only one category of professionals whose dates were problematic, and they were film stars. Now the second category is arbitrators, and I mean every word of it. When you are appearing in before an arbitral tribunal and the next date is being decided, everyone would bring their diary and say, then no, up to November I am booked. Somebody would say up to January I am booked. So matters are adjourned for 6 months, leaving the party at the request of the arbitrator to move under section 29A, seeking extension, and parties have no choice. They have to get it extended because nobody can take the call that now we declare that the arbitration stands terminated. What can be the solution of this problem? There is a solution of this problem in institutional arbitration in Singapore. In Singapore, when you choose to have institutional arbitration as against the ad hoc arbitration, the arbitrator is supposed to give his engagement list next 2 years. And the institute which decides whether to accept that arbitrator as an arbitrator in a particular dispute or not will decide whether he'll be able to discharge his function. If he is booked, he is overbooked, he is overworked, he has taken more than he can chew, then he will not be selected. If it is left to individual discretion of arbitrators, chances are that more and more arbitrations is always a luring thing for any human being. This is one solution where we can incorporate under the statutory provision that before accepting any arbitration, you will have to disclose your 2 years dates. What are you doing for next 2 years? Whether you will be able to devote time or not. The courts are being now burdened with section 9 applications. All honorable district judges and honorable high court judges are facing this issue. Section 9 applications. Now, it is in contemplation that the parliament may come out with emergency arbitration. In some countries, in some jurisdictions, it is already there. The arbitral tribunal would be as contemplated in the arbitration clause. But in case of any interim award, interim order, you can request for an emergency arbitrator. One arbitrator would be selected. He or she would sit, decide the matter, and that order would inure till the main arbitral tribunal is constituted, and that tribunal will have the jurisdiction to either confirm that order, modify that order, or vacate that order. So mostly Section 9 applications will be reduced. Unless the lawyers have their own ingenuity, they might come out with some new idea and come to the court. That's another thing. Next point is that we must have a robust, and this is for especially for Gujarat. The Gujarat has an intrinsic arbitration in its nature. Before the Arbitration Act was codified, we had Majur Mahajan Sangh, where the disputes between the mills and the employees used to be settled by conciliation and arbitration. So that's a part of our culture. We don't need any act. But mostly the arbitrations go to either Bombay or Delhi. The question we should be asking to ourselves is, why? We must have a robust institutional arbitration system which can be trusted, so much so that other people from not only outside the Gujarat, but from outside the nation also comes, the way people go to Singapore. Singapore arbitration is not Singaporeans only, it's for the world community. And Gujarat has that potential in. Now, last point. And last point, only the district judges and the high court judges can solve the problem, because the very heart and soul of arbitration is less challenge and effective and quick adjudication. To ensure that there is less challenge, Section 34 is so designed that mostly you cannot invoke 34. Somebody has said that it has yesterday some conference said that there are 8 pigeonholes in Section 34, but the pigeonholes are so narrow that even a sparrow cannot enter. Second point in 34 is that the words are very consciously used in a vague manner. You have patent illegality, you have perversity. Now something can be illegal for me, but for Unmesh it may be patently illegal. For me some order can be wrong, but for Unmesh it can be perverse. It's too subjective, but there is no other option. The legislature cannot define certain terms, and that is where a judicial application of mind will come. And the only test, according to me, is if you can know to read the award between the lines, you will be able to find out perversity or patent illegality in no time. If you read the judgment as if you are exercising revisional jurisdiction or appellate jurisdiction or any other jurisdiction, it will not be possible. You will have to read between the lines what the tribunal has done. And it may fall or may not fall within one of the categories. Now, another thought. See, the High Court, Supreme Court, District Court, all courts are burdened with several challenges. 34, 37, 37 from interim order passed under Section 17, 34 against the award, the final order of 34. Can we consider having a tribunal, special tribunal, for the purpose of deciding only Section 34 disputes and relieve other courts of deciding those disputes? Because right now, what is happening is that the judges are already overworked, whether it is district judge, high court judge, or Supreme Court judge. They have more on their plate than they can eat. Humanly not possible to deal with this kind of a backlog. And now we are adding to it. If this is removed and if it is shifted to the tribunal, but it will have to be very carefully done, because so far our experience as a nation of tribunalization has not been very successful. Second thought, and I wish in the next year, next session, this can be considered. Can there be one appeal as of right provided for, one appeal only, which would not be bound by the shackles of section 34? Because many of the people do not go for arbitration because of the very stringent condition they have to fulfill if they suffer a bad award while challenging it under section 34 of the Act. These are all broad ideas because this is the only way we can decide to move forward based upon our experience. Last, and this is something which is troubling. I don't know whether it has reached Gujarat or not, but it has reached India. This problem has reached India, and world over, this is being discussed. That is use of artificial intelligence in arbitration, whether it should be permitted or not. And so far, the use of arbitration, this artificial intelligence has been proven to be a bad idea. There are instances, and I'm not going to give you instances, but take it from me. I have read the judgments in US especially, and one in South Africa, where the lawyers are using the artificial intelligence for the purpose of preparing their written submissions. And I was shocked to know, maybe I'm not a very techno-savvy person, and therefore I was shocked, but you people might be aware of it. The artificial intelligence tool hallucinates. Hallucination means if you feed that these are the facts of my case, it would make out a judgment for you, which is a fictitious judgment, completely fictitious judgment. And those judgments are cited, judges have found out, and ultimately it was found that the lawyer has used ChatGPT. Recently, in arbitral proceedings, this question has arisen, and possibly this is for the first time it has arisen. It's in La Paglia versus Valve Corporation. It's an American case where the arbitrator was hurrying up that I want to start my vacation, so please hurry up, and everybody wound up. We always try to please the arbitrator or the honorable judges. That's the minimum we can do. So they hurried up. He went on a 1-week vacation, came back and declared an award. And some of the paragraphs were very, very generic and general. The person who suffered the award, his lawyers found out that this is the work of ChatGPT, etc., etc. And he has given 10 reasons that this is outsourcing of essential core judicial function, and therefore, see, very interesting argument is raised. Arbitral award has to be a reasoned award, and the word reasoned award would necessarily mean reason of the arbitrator. If you outsource your core judicial function, the award suffers from patent illegality. The matter is pending, it's not yet decided, but I feel that would be a landmark decision. Friends, my apologies. I have even keeping you waiting for this much also was not morally justified, but you have been very decent, very kind, and very polite. I'm thankful to Honorable the Chief Justice for inviting me. It's always a pleasure, and I thank all of you for a very patient hearing without any clapping in between. Thank you.
May I now request Honorable the Chairperson to kindly facilitate the Solicitor General of India, Shri Tushar Mehta. May I also request Justice Karya to facilitate Justice Dhanuka, please. Hello, Justice Karya, may kindly present Mr. Raja also. Lastly, if I may request Justice Karya to felicitate Mr. Shukla.
May I request everyone to please rise for the national anthem.
जनगण अधिनायक जय हे भारत भाग्य विधाता पंजाब सिंध गुजरात मराठा द्राविड उत्कल बंगा विंध्य हिमाचल यमुना गंगा उच्चल जलधि तरंगा तव शुभ नामे जागे तव शुभ आशीष मांगे गाहे तव जय गाथा जन गण मंगलदायक जय हे भारत भाग्य विधाता जय हे जय हे जय हे जय 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 हे
Jai. Natural. Thank you. Thank you.